Call the list. কি তুই মেনশন কোথা থেকে আছে? হ্যাঁ হ্যাঁ দিন।
This has come my instance, my lord. My lord has been gracious enough, my lord, to post this matter as to be mentioned, because, my lord, I mentioned this matter for extension of interim order. So, my lord, my learned senior friend, Mr. Dey, my lord, is appearing for the respondent. I've already talked to him. He's just coming up. And he doesn't have any objection with respect to the extension of the interim order. That is what he has specifically stated. He's anyways, my lord, coming to your lordship. Last order to last order to last order to because, my lord, this appeal, my lord, has been going for since 2013. Nobody appeared for the respondents. But first time, my lord, I have been told by my lord senior friend Mr. Chandi Charan De that he is, my lord, instructed to appear on behalf of the
On behalf of
respondents.
respondents,
All of the respondents.
all of the respondents.
Yes.
One
So-
respondent has expired, pro forma respondent.
Yes, my lord. He has been.
You have to take steps.
My lord, I will be just doing that, my lord. The pro forma respondent number, my lord. I'll just check and, my lord, I'll just. Lordship, can you grant me the liberty so that I can file the.
I have paused the order in respect of his name. Pro forma respondent Gogendra Singha.
Yes, my lord. My lord is referring to the order dated, my lord.
My last order, 6th of November.
Yes, my lord. My lord, I'll just take your lordship's leave, my lord, so that I can just do that thing, my lord, in course of this week.
Okay. Have you filed any can?
No, my lord. I mentioned this matter before the expiry, my lord, before your lordship.
Please take down. Learned counsel appearing on behalf of the appellant submits that the interim order passed by this court on the earlier occasion has expired on 10th of January 2025. Also be prayed for extension of interim order. Having heard the learned counsel for the appellant and considering the fact that the instant appeal is pending since 2014, let the interim order passed by this court on the earlier occasion is further extended till January 28th. February 28th.
My lord, grateful.
Or until further order, whichever is earlier. Full stop. Next para. The appellant is directed to take steps upon the deceased respondent, namely
Gogendu, my lord. Gogendu Sinha.
Gagendra Sinha.
My lord, Gagendu Sinha.
Gagendu. Gendu. Gagendu Sinha. In the meantime,
Grateful.
let the matter appear in the list. No, you take steps. It will not be appear.
My lord, it has been, my lord, running in your lordship's leave under the appeal.
No, appeal hearing cannot be taken. It will be appear if you file a steps or application, that will be appear under the heading of application.
But let it come off, my lord, after 2 weeks. In this meantime, I'll just file the application, application, and it will be taken off subject to.
Let the matter appear in the monthly list of February. Next.
My lord, my learned senior, my lord, was appearing for the respondent.
Yes.
My lord,
You are appearing on behalf of respondent number?
Sorry.
All the respondents.
All the respondents. One pro forma respondent has expired.
Oh, তাহলে তো তোমাকে আবার সাবস্টিটিউশন করতে হবে।
I have directed him to take steps.
Yes, ma'am.
The interim order was extended to 28th of February, and the matter shall appear in the list, in the monthly list of February.
Yes, ma'am.
If it is ready, then or if
No,
the
my lord,
pro forma
paper book,
respondent
paper
is
book.
not appeared,
My lord,
না, না,
paper book,
স্যার আমি
paper,
সাবস্টিটিউশনটা করি তারপর
my lord,
no,
paper
let
book,
you
there
take
is any.
instruction
My
whether
lord,
pro forma
if your
respondent.
lords,
Yes.
if your lordship pass the order to make the paper book and other things or other,
নিয়ে তারপর করতে
তাহলে অনেক দেরি হয়ে যাবে, বুঝছো না কেন মক্কেল তো?
No problem.
My lord,
That
your
even
lordship
it is-
can pass the order, initial order to make the, my lord, the paper books and other things.
Paper
And
books are not
notice
ready.
was given,
Please take down.
notice was given to the,
Learned counsel, Mr. Dey, appearing on behalf of the respondent, submits that the matter is pending since long, so necessary direction may be passed for preparation of paper book by the appellant. Considering the situation, the appellant is directed to prepare the requisite number of paper books
পারে
and file the same with the department. After serving a copy of the same to the learned counsel for the respondent.
পারে
In the meantime,
yes, ma'am.
you make it within February.
And my lord, notice is also
Notice of
second
appeal
appeal.
has notice of appeal.
Notice of the second appeal, my lord, is also.
Notice of the second appeal. You are appearing.
all of them are
All of
already
them-
served.
Yes,
All of
yes.
them are served. It is there in your
Have
lordship's
Have you
record.
served the notice?
All of them. It is already there in your lordship's
Then,
record.
my lord,
If notice has been served, then
All of them.
then, my lord, nothing is required.
But it should be not informal paper.
informal paper.
Informal, second
Informal
appeal.
paper. Right. Informal paper. Requisite number of informal paper.
Great.
Yes, ma'am.
Yes.
Let it come on under the in the monthly list of February, my lord. I'll be doing this thing in this meeting. Great.
In the meantime, you prepare the paper.
Everything.
Yes, ma'am.
Great.
Next. No one. Forget it. Yes. Not today. Next.
I'll forget. There is something happening, my lord. In the meantime, my lord, during the pendency, my lord, 27 December, an order was passed in this matter. Lord, I have to file a supplementary affidavit to challenging this in this case. This is the order which has been passed on 27 December. Therefore, my lord, I have to challenge it by filing a supplementary affidavit before your lordships.
So you have to, this is a new cause of action. You have to file a separate writ, not this writ.
But
This fact may become in the new writ, but this
with the
is a,
supplementary affidavit, it can be disposed of. My lord.
uh,
If I tag with a supplementary affidavit,
no. You have already separate cause of action in this matter.
but I have challenged for
You have challenged for running
sub-center.
the sub-center
Yes.
in a, that is the altogether separate issue, and the new order has been passed.
But that sub-center is now detached.
Whatever maybe you challenge
Therefore,
the
my
matter.
lord, I have
You
that
challenge it.
sub-center is
No, you
detached.
challenge it in a fresh writ, not in this writ. Okay. Please take down. Learned counsel appearing on behalf of the petitioner submits that the concerned authority has passed an order in respect of the instant subcenter, in respect of the running of instant subcenter on 27th of on December 27, 2024. Learned counsel for the petitioner intends to prefer a separate writ considering the submission. The instant writ petition
It will be disposed of with a liberty to
yes,
petitioner to file a separate.
instant writ petition has nothing to determine further. Thus, the instant writ petition is disposed of with a liberty to sue afresh on the self-same cause of action.
Yes.
Let the order dated December 27, 2024, passed by the concerned authority, be taken on record.
Yes. Yes, deeply.
Disposed of.
Martin Millard, I am for the petition.
Yes,
My lord initially heard the matter on several occasions and lastly on 11th December 2024. Heard the matter and fixed for passing appropriate order as
May I just pray only one thing?
my
here?
learned
I
friend
have
failed
not.
to submit any report in spite of directions to file a report. That is
May I
on
be permitted
10th
to make
September
a submission, my lord?
2024. 10th September 2024, my lord was pleased to pass an order for furnishing a report.
okay.
This is relates to vacancy notice. Initially issued a vacancy notice. Petitioner made application without conclusion of the said application vacancy notice. In as per
17th February 2022, there was a notice,
Yes, ma'am.
vacancy notification. Thereafter, the authority again issued a vacancy notification on 7th June
on the
2024.
self same place
You are saying that
without
you
conclusion
have
of the
applied for the vacancy on 17th February 2022. They have not exhausted the procedure
Yes.
and issued the fresh notice. I want the report. Whether
Yes,
it
Report
was-
is there.
Yes. What happened?
We have cancelled these earlier.
You have cancelled that.
Yes.
You challenge it.
and it's
Okay.
Yeah, definitely, definitely. Kindly peruse the same from paragraph 11 onwards. That's the penultimate paragraph, my lord.
Paragraph 11.
Yes, page 4.
Yes.
Now the may I read out, my lord, together.
Yes.
That thereafter a further proposal for declaring the renotification of the said vacancy has been sent to the food. If I think we should start from the paragraph 8 onwards.
Yes.
After scrutinizing aforesaid inquiry reports of all documents, the relevant file along with the records was sent to the selection committee such and such. From course of the said the selection committee not recommended any of the application
Okay.
because none of them was satisfied. Well, this is the reason Lordship would see. Now Lordship see paragraph 11.
Yes.
Thereafter, further a proposal for the declaring the renotification of the said vacancy had been sent to the food and supply department with this office memo number such and such, and after some corrections, again a fresh renotification proposal had been sent to the food and supply department with office memo number such and such, and after obtaining the approval, the said vacancy published on newspaper like the Bartaman and Times of India and Sanmark on 18/7/2024. It was also mentioned that the notification that the last date of the submission of the application was 4 September 2024. Millet, the court was not violated anything. Millet, it was there. Millet.
Okay. Please take down. The instant writ petition was filed challenging vacancy notification issued by concerned SCFS dated 7 June 2024 in respect of central location, in respect of a vacancy location at Jagatpur within bracket Bank of Baroda, comma Jagatpur, under the district of what district?
North Chobbish.
North
Not
Chobbish.
24 Full
No.
stop. It is the case of the petitioner that the authority concerned had issued another notification, had issued earlier notification on 17th February 2022 in respect of the same location. It is the case of the petitioner that the authority concerned, without exhausting the procedure, had again issued the impugn notification on June 7th, 2024. Full stop. Mr. Sengupta, appearing on behalf of the state authority, has submitted a report. Full stop. It appears from the report that in terms of the notification, vacancy notification dated 17th February 2022, the applications were received, comma, inquiry was conducted over the proposed shop-cum godown of the intending applicants, comma, files were sent to the selection committee to district controller, FNS, North 24 Parganas, for further course of necessary action for the instant matter. Full stop. The district selection committee not recommended any of the applicants because of the fact they are none of them satisfy the GO number 1707.
Eligible criteria. Kindly.
Yes, none of them. কি বললাম বলো?
Only mention the geo
Satisfy
number.
the
nothing has
eligible
been mentioned.
criteria as enumerated in GO number 1707-FS dated 2/7/2014. Consequently, the authority had to issue a fresh notification on 7th of June 2024. Full stop.
By cancelling the earlier.
By cancelling the earlier notification. Full stop. Having heard the learned counsel for the state respondent, it appears to me that the challenge in this writ petition by the present petitioner cannot be entertained at this stage. The authority concerned has correctly issued the further notification by cancelling the earlier notification dated 17th February 2020. Under the above observation, the writ petition is disposed of.
Mine.
The report filed on behalf of the state authority is taken on.
Very careful.
Next.
My lord, I am appearing for the petitioner in this matter.
Yes.
My lord, not at all. There was My lord, on last occasion, there was a peremptory direction on the respondent authorities to file their report. My lord, time and again they had sought for adjournment on the ground to file the report. My lord, there was a direction. My lord, on last occasion, a peremptory direction was filed by the, was passed.
The file report is written.
Have you any instruction, madam?
Lordship, Mr. Chatterjee is appearing along with me
Yes.
and he is not present over here. So I'm unaware.
What is the issue about?
My lord, pursuant to
FPS dealership?
pursuant to surrender of a APS dealership, a vacancy arose in a place. My lord, subsequently the government issued a notification for opening a new shop in that same place. Subsequently, they had re-notified that instead of place A, where the vacancy arose, they will open a fair price shop in place B, which is 2 kilometers away, and I had to cross
You have
the
to cross the
highway.
highway.
Because of which all the petitioners and the other consumers who are there in the locality are facing problems. We had submitted a representation. My lord, pursuant to that, our only prayer is that the shop be opened in the old place where the vacancy arose, so that it will be convenient for me.
Let the authority decide the issue. Let the authority decide the issue. I can pass an order to framing certain time bound.
My lord,
Okay.
my lord. My lord, meanwhile, my lord, until unless this issue is being decided, no such shop be opened in a new place. Otherwise,
Whether any vacancy was declared?
yes, my lord. My lord, I will show the notification. My lord, takes up page number 17.
It's 18, 817, 18.
Page 17. My lord, serial number 12. Initially, because of the surrender, a vacancy arose in this place. Gram Debogram, Kulaichundi, Puraton Bajar, Piccadilly Cinema কাছে. Subsequently, what they did, they re-notified and changed the place, which appears in page number
Lordship,
18.
there is an affidavit.
Very good.
Served. একটা phone করতে পারতে তো? You are running. দিয়ে দিয়েছি। দিয়ে দিয়েছি।
Yeah, nothing.
OC দু তিনজন running. That's right.
Do you want to use exception?
My lord, let me take instruction. It's a detailed affidavit.
Issue is that
Inquiry,
if
yes.
one village is there and one highway is crossing the village. So one person residing one side of a highway can say, I cannot go on that side. But if the location, if the shop is open in the other side, the villagers of either side of the highway may say that I want a shop room here.
And
My lord, I have
Cross the
My lord, I have instruction that instead of opening the shop in the old place, they are opening it far away, which is 2 kilometers away.
Diwali
And we
Rashid
need
is
to-
also there, your
We
lordship.
need to
The
cross
same
the
Diwali
highway
Rashid.
intersection. My lord, let me take
Moucha is the same.
instruction on this
Yes, you take
detailed
it. Please
affidavit.
take down. Report in the form of affidavit filed by the respondent number 3 is taken on record. Copy, sir. Petitioner intends to use exception. Let the exception be filed within 2 weeks from date.
My lord.
Let the matter appear in the list at the monthly list of
My lord, kindly fixes a date. Any date.
February.
Any date in the February. My
It
lord.
would be appear under the heading of hearing. So I cannot say what is the date. Let it appear in the February. in the monthly list of February. Report be taken on record.
Much obliged.
My lord, I am for the
Yes.
reply file করার কথা ছিল
exception. I am seeking 2 weeks time for filing.
Again, 2
exception.
weeks time.
Lordship, the petitioner she is not well for she is suffering from illness. For such reason, we will not file our exception.
দিয়ে দিয়েছি I have given and I am not
In December.
and I will not shout
That I want to play. I want to play tit for tat, my lord.
just because you have given me a lot of
2 weeks time to file my exception.
time?
2 weeks time. There's always a
Okay.
mutual understanding between me and Sina.
An accommodation sought for on behalf of the petitioner to file affidavit in reply. Let the reply be filed within 2 weeks from date.
Obliged, deeply obliged.
Let the matter appear in the list under the heading of hearing in the monthly list of February.
Lordship will kindly allow out to retain its position.
No,
Otherwise,
no.
if it
Hearing
comes
will be
under
there.
hearing তে এসে গেছে
All matter come under the heading of new motion.
hearing, my lord, then my lord, perhaps I will not stand a chance, my lord. Please,
কালকে
my lord.
অনেক হিয়ারিং হয়েছে অনেক শুনানি হয়েছে
Yes. Come on, next.
I am for the petition.
Yes, your lordship I am seeking for some time 2 weeks time
Why? What is this?
You know,
direction ছিল direction was there your lordship to file
my case is page number 11. Petitioner is a page dealership.
Yeah.
Thereafter, he is holding only 564 card.
564 cards.
Yes. And according to circular, kindly see page number 13.
3,000 to
Yes,
4,500.
In spite of that, they are declared vacancy on the same place.
And you are holding
564.
only 564
Yes,
cards.
I have annexed. Kindly see page 12.
564 cards.
Yes.
No.
Yes, Miller. Kindly see page 12. 12.
I would like to draw your lordship's kind attention towards the
Well,
last
fine,
order that has been passed না, না, ওই last order
আরে
টা
ঠিক আছে আমি
বলছি।
সেটা
Just last order আমি বলছি or
Only
আমি
60
কিছুই বলছি না।
564. Thereafter, I made a representation, but they are going to fill up the vacancy. Page 12, kindly see. 564 only. Page 12.
He is running with 564 cards.
Yes, yes, it is.
Why?
Kindly see the lordship's last order.
Last order dated?
Dated
Third October.
third October.
Yes, kindly see.
Okay. October 3rd.
Yes, madam.
Submissions were reported.
তো বলছি
আমি just lordship শুনলেন ওই দিন শুনছিলেন না ওই দিন অন্য বেঞ্চ ছিল just indicate করছি
Yes.
Yes,
Justice Chat.
yes, madam.
Justice Chattopadhyay was there.
Yes.
Wrong-standing complaint against the writ petition.
I'm only challenging the vacancy
And
notice
kindly see
on the self-same.
last. Needless to say that the same is only an apprehension without being backed by any alleged potent illegality in the process.
Right.
There is no scope at this moment for grant of interim order in this case. However, the case is required to be determined by filing affidavit as parties. I've just brought this to your lordship's notice, and after that I leave.
But on the same place, vacancy has been declared. Can you see page 14?
However, affidavit has been declared, affidavit has been directed to be filed. So you seek 2 weeks.
In the meantime, I pay me like you can eat this step taken by the authority concern, that will be abide by the result of the.
Already interim order was refused. Again, how you can ask for the interim order? Either you challenge the order.
But any step taken by, I am not paying any interim order. Any step taken by the authority concern, that will be abide by the.
No. Today I shall not pass this order. Please take down.
Lordship, please.
Planet Council appearing on behalf of the
Only application.
state respondent seeks accommodation to file affidavit in opposition. Having heard Planet Council for the state authority, the filing for time for filing affidavit in opposition by the state authority is further extended till 2 weeks from date. Let the matter appear in the list under the same heading on February 11th, 2025.
Get. নাম আছে আছে petition
90 minute IPF for the petitioner, my lord.
Lord, I am appealing for the prior respondent.
We have given the opposition has been filed.
Today is the first day it's been called.
Okay. Zareen है ना?
Oh, it's with your throat.
अच्छा.
Affidavit.
Yes.
Copy, sir.
Copy, sir. আমারটা তো কিছু না।
May I file, my lord, the exception, my lord, and the affidavit reply, my lord, to the affidavit opposition filed by, my lord, the private respondent.
Please take down.
My lord,
Report in the form of.
it is reading, my lord, matter of fact.
Yes, I said here it. Report in the form of affidavit filed on behalf of the state respondents are taken on record. Exception to the report filed by the petitioner is also taken on record. The petitioner also filed an affidavit in opposition, also filed an affidavit in reply against the affidavit in opposition filed on behalf of the respondent number 6. Let the reply be taken on record. Okay? Yes. What is
Sir,
the
may I
matter?
take a preliminary point that the writ petition is not maintainable. Your Lordship, my lord, kindly see the prayer.
So you have raised the point of non-maintainability.
Yes, my lord.
Yes.
My lord, the petitioner.
What is the case about? What is the matter about?
Matter is
My lord, the
about.
matter is about, my lord, the petitioner, my lord, having challenged, my lord, the license issued in favor of the private respondent, my lord, on various grounds, my lord, which has ultimately boiled down only on 2 grounds, my lord. One, my lord, is with regard to conversion, my lord, and the second, my lord, is with regard to, my lord, the mandatory requirement of having shed before the shop, my lord. These are the only 2 grounds, my lord, that I'll be urging for, my lord. And my lord, the only report that I'll be praising for, my lord, would be the report of the state. That's it.
My lord, my preliminary point is that his application has been rejected, but he has not challenged the rejection order in the writ petition. Until the rejection order is challenged, he cannot pray for appointment in his favor. Because until the quashing, the termination or rejection of the application is quashed, but there cannot be. In this regard, my lord, I am relying upon a division bench judgment also.
Yes.
उनकी कॉपी में बेहतर है बाकी तभी दीदी को एग्जैक्ट
When it has been held,
একটু পড়তে তো পারছি এটাই খালি একটু দেখো তো
my lord,
Refer to the page.
page 13, there are 2 grounds, my lord, that first of all, he will have to prove that he was eligible, and second was that he is not challenged. My lord, kindly come to page 13.
Yes.
Paragraph 10. In the present case, at the cost of repetition, we would say that in the writ petition, the petitioner has not challenged the rejection of her application by the state respondent. As she had not challenged the rejection of her application, it was not the duty of the state to convey to her as to on what ground the application has been rejected. Nowadays, after coming to force of Right to Information Act, when all information saving the accepted can be obtained, the petitioner after rejection of this application should not have waited for communication of the rejection. Here, my lord, the case was that rejection was not communicated. And here also, my lord, there is no communication of rejection. Informed to it by the state. Such is also not the duty enjoined to state authority in the relevant control order of 2013. The writ petitioner had admittedly filed WPA number such and such, praying for its engagement as MR distributor. Third writ petition is perhaps still pending. We are not concerned with that, my lord. Therefore, the writ petitioner filed the present writ petition. The writ petitioner cannot feign ignorance as to on what consideration it was found ineligible. It was therefore the duty of the writ petitioner, number one, to plead and prove that it is otherwise eligible, and overlooking its eligibility favor has been granted to the applicant in violation of Article 14 or in derogation of duty enjoined to the respondent in the relevant control order. Taking into consider the entire material on this point in its entirety, we are constrained to hold that the petitioner had neither legal right to enforce in absence of any pleading, showing her ineligibility, and the state respondent knows corresponding duty to perform in respect of the writ petitioner is number one. Well, I am relying upon this.
Yes.
So, my lord, in this matter also, he has not challenged the rejection order. Therefore, his writ is not maintainable. Moreover, my lord, he has not annexed any document wherefrom it can appear that he is otherwise eligible. First of all, who can be an aggrieved party? Your lordship has passed judgment in other matters also, my lord, considering the judgment of 3 judges bench of 1977-1 SCC 486.
Yes.
It is one point, I am giving it to your lordship kindly. I am reading it. Paragraph 9.
Sorry, what citation? 1997?
1977, 1 SCC 486.
1 CC
486.
486.
Well, paragraph 9, I am reading this, my lord, I am giving it to you.
Yes.
The High Court rightly dismissed the petition. It is elementary, though it is to be stated that no one can ask for a mandamus without a legal right. There must be a judicially enforceable right as well as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has a legal duty to do something or to abstain from doing something. Even, my lord, in one judgment passed by your lordship,
है तो आपके पास
जिसको क्या देंगे
कभी नहीं देते।
अभी दिया पहले वाला दिया
आप मान लेते नहीं क्या
उनके साथ हैं
Yes.
My lord, your lordship has passed in one of my case where I have lost that the state authorities to determine the candidature of persons. It has been the case. Page 9, my lord.
Yes.
The state authorities to determine the candidature of persons who applied for the vacancy. In deciding said issue, the state authorities opted view that prior respondent of 5 is more suitable candidate than the petitioner. The area of the sales counter of the respondent of 5 may be less. Even, my lord, it was less than the specification of the, but the state authority thinks it necessary and deems it to fit to give a license for the purpose of smooth public distribution system of the food grain in the locality. The authority to select and domain to determine suitability is only upon the state to determine the candidature of any person. In the writ petition, it is only to look into whether the decision of the authority is biased, purposive, or illegal. Considering the entire facts, my lord, the state authority, competent authority. Now, my lord, what has happened? In this case, what happened? Your lordship has held that there was no pleading of bias
1997.
against against the state. And on this
1977.
contest, your lordship have dismissed this.
14.1.
Yes.
SC
So, my lord-
486.
One SCC
SC 486.
and the second
So, my lord, on these three subjects, my lord,
चैलेंज किया ना आप लोग
I am,
अपील किया ना इसमें
नहीं.
नहीं किया
my lord, I am seeking your lordship intervention to reject the writ petition on the ground of maintainability.
Yes.
In the instant case also, according to the report of the state, he is not eligible. He has got less mark than the prior respondent. And the state authority has determined it that I am the suitable candidate. Therefore, no interference should be taken by your lordship in the instant case.
That's all.
My lord.
Yes.
For the time, if your lordship wants to hear me on the merits, I shall again place waiver.
Paragraph 6 onwards, your lordship, the affidavit that we have filed.
may I not place my case the private respondent has submitted now the statement of the petitioner will wait
I submit on the maintainability. Let him know.
Yes. You start. I will hear him.
Yes.
But so far as my lord, the maintainability is concerned, my lord, if your lordship sees, my lord, the report filed by the state, my lord, I have not been held to be ineligible. I have been held to be eligible. The only issue is that the private respondent
Yes.
has received 1 marks more than me. Before, my lord, the
So state has
Sub-
not declared you ineligible. Okay.
1 and 2.
in fact, my lord,
1 and 2.
in the presence of the state, my lord, I must, my lord, acknowledge that perhaps, my lord, this is one report filed by the state, my lord, wherein, my lord, everything has been truthfully stated, my lord. Everything has been placed before the court. Now it is for the parties to argue. And
Yes.
whoever convinces your lordship, my lord, would get an order.
Yes.
But I have not seen such an honest report, my lord, filed by the state.
State always file honest report.
Yes, yes.
Absolutely.
Yes.
Thank you. Thank
Yes,
you.
yes.
I must admit that.
The state must thank the petitioner lordship.
But I must acknowledge it.
Always filing
Which
honest
usually
report.
does come the same
Lordship,
way.
lordship has said we take it as a very positive.
Exactly.
Whenever there is a document, state cannot.
Yes. Yes. Very yes. Yes.
Now, my lord, coming, my lord, to the, as I said, my lord, coming directly, my lord, to the report filed by the state. Nothing else would be required, my lord. Nothing else would be required. If lordship comes to, my lord, paragraph 6. After receiving the applications in response to the advertisement for FPS dealership, a field inspection and spot inquiry was conducted by the inquiry team on 28th of October 2022. Well, these dates are very important. The said team thoroughly inquired the applicants in respect of the nature of land, area of land, and condition of godown. So, my lord, they themselves say that yes, we did inspect them also inter alia, my lord, on the nature of land. Financial solvent, all the criteria are given. Then what it is specifically mentioned herein that after conducting a thorough inquiry by the inquiring team and also relying on the submitted documents through online process, the subdivisional controller Badaipur came to a finding that Abdul Hakim Mullah, who is the petitioner before your lord, fully complies with government GO 1706 and 1707 as measured on the shop is 661 square feet, and there was a shade in front of the shop to accommodate a long queue and other criteria for establishing a new FPS. But it was also found that the shop of the petitioner herein was rented and not on ownership. This is why, my lord, I got 2 marks less. On the basis of the eligible criteria, a system generated marks, my lord, I got 59 out of 75. Next, my lord. On the other hand, at the time of inquiry, it was found that Abdul Rakib Boiddo, who is the respondent number 6 herein, complied with government order so and so, but did not fully comply with GO 1707, which meant that in spite of having a shop come go down measuring 774 square feet, he did not have a shade in front of the shop to accommodate a queue. So, my lord, so far as this criteria is concerned, lordship will kindly come to page 8. Page 8, my lord, is the notification. Now, page 8, if your lordship sees, my lord, part 2, my lord, right at the bottom, my lord,
Yes.
Right at the bottom, eligibility criteria. So, my lord, the criteria is mentioned in the part 2, my lord, are all the eligibility criteria. That means for an applicant to be eligible to be offered with an offer letter or a license, my lord, these criteria have to be fulfilled. Now, my lord, lordship turns over, my lord. Roman 4.
Yes.
The applicant should possess a suitable godown as per notification issued by the department so and so, dated so and so, as amended by notification number so and so. Admittedly, my lord, this was not complied with. Within the vacancy location for storage, my lord, then 400 square feet, 200 square feet, hill area, my lord. And then, if your lordship sees, my lord, there must be shade in front of the shop to accommodate at least 20 people who may wait in the queue. So this, my lord, is one of the eligibility criteria.
Yes.
And it is only once, my lord, the applicant crosses the eligibility criteria, my lord, that, my lord, the other aspects are gone into. And, my lord, the eligible candidates, my lord, as per, my lord, notification of 17th August 2021, my lord, clause 5, my lord, the eligible candidates are placed before, my lord, the district levels selection committee, my lord. So here, my lord, the private respondent had admittedly failed on one of the eligibility criteria. And that is why I said, my lord, very honest, lord, affidavit by the state. But the shop of the private respondent was on ownership and there was adequate space in front of the ground for unloading of the food grains. Therefore, on the basis of the eligibility criteria, a system generated marks, my lord, he got 60, which means 1 marks more. But here I'm joining issues, my lord, could not, my lord, have been, my lord, marked because of, my lord, the eligibility criteria having been missed. Next, if your lordship turns over, my lord, this is 1 point. Next, my lord, paragraph 8. Paragraph 8 says, at the time of the application, the classification of the land of the respondent number 6 was Shali, but respondent number 6 had already applied for conversion of the land to Bastu. Now, what, my lord, this starts with, my lord, at the time of application. My lord, kindly turns to page 18. Page 18, my lord, is the inquiry reports in respect of the private respondent, my lord. Lordship will kindly see, my lord, 6, column 6, my lord, date of this application 26/9/2022.
Yes.
26/9, lordship will kindly mark the dates. My lord, as I said, my lord, the dates are important. So, my lord, the date of notification is 10th of June, and, my lord, the date of application by the private respondent is 26th of September 2022. And they say that at the time of application, my lord, he had already made an application for classification. Now, this application, the alleged application, lordship will find at page 25. If your lordship turns to page 25.
Lordship,
Yes.
Now, page 25, my lord, is the alleged application, perhaps which has been annexed by the state, my lord. Perhaps this is what must have been submitted, my lord. If your lordship sees, my lord, I think, my lord, this is not very legible, but still, on the right hand side top, below, my lord, the page marking, perhaps it is 29/2022, written by hand, handwritten, my lord. Now, if your lordship turns over, there is a designated place for place and date at the bottom,
Yes.
which is blank. Now, my lord, this document that they say, my lord, is the application, my lord, does not contain any mark of receipt. Nothing is there, if your lordship sees. Nothing is there. And, my lord, this document, perhaps, my lord, was brought into existence only for the sole purpose, my lord, of, my lord, getting out of the rigors of, my lord, the eligibility criteria. Why I say so, my lord? If your lordship turns over now, my lord, this document too has been submitted by the state Now your lordship sees, my lord, her application dated 22/6/2023. Page 27. Lordship is at page 27.
Yes.
This, my lord, is the conversion certificate. So what is the date of the application? 22/6/2023. So, my lord,
This is in respect of Abdur Mandal, like that. The name?
it is, my lord, in my copy, it is absolutely
My lord, it is
ineligible,
No, no,
but
my
I
lord.
believe it
It
is.
is
It
Abdul
should be
Rakib Vaidya at the top. Abdul Rakib Vaidya.
Abdur Rakib
Vaidya.
Pajja.
That is private respondent, madam.
Should be, my lord. Should be. My lord, this mistake the state will not do, my lord. Should be.
Yes.
So, my lord, the date of the application for conversion is not, my lord, 20th September 2022, but it is 26th of June 2023, which is much after the date of, my lord, the notification, much after the date of the application, and much after the date of the inspection. The date of the inspection, your lordship will get at page 18.
Yes.
If your lordship kindly turns over to page 18. So date of inquiry is, my lord, 28th of October 2022. So, my lord, an official document which contains the date and has all the details, my lord, specifically says that the date of application was 22nd of June 2023, which is after the date of the notification, after the date of the application of the private respondent, and after the date of the inspection. So therefore, my lord, this statement made at page 8, perhaps, my lord, the state was misguided. No application was ever made on 20, my lord, before the date of application of the private respondent. Now, lordship comes back to paragraph 8.
Yes.
Paragraph 8, at the time of application, the classification of the land was Shali, but the respondent had already applied for conversion of the land. No, he had not. And if my learned friend today produces any paper which shows, my lord, any paper from the concerned department of the government that, my lord, the application was made prior, my lord, then perhaps they might have a case, which again, my lord, I will say no, but perhaps, my lord, can be an arguable case. Now, my lord, this application, if your lordship turns over page 28, was allowed on 28th of July 2023. And if your lordship sees, my lord, even the notification which the state has annexed, my lord, specifically mentions that, my lord, the nature of the land either has to be Dokan, Bastu, or commercial, which your lordship will find at page 10. Which your lordship knows, my lord, by now, my lord, that this is one of the criteria, my lord. Then your lordship comes to paragraph 9. As explained here and above, the final scores of the applicants were system generated and the applications were thereafter sent to district level state selection committee, my lord. Paragraph 9. I say, my lord, 1, because the first eligibility criteria with regard to the shed as noted by the state itself was not complied with, my lord, which is one of the eligibility criteria, my lord. The private respondent becomes ineligible. Now, if he becomes ineligible, my lord, in terms of clause 5 of the my lord, notification of 17 August 2020, my lord, with his candidature could not have been placed before the district level fair price shop selection committee.
Yes.
Now, if your lordship turns to page 23, which is the chronology of my lord, the application of my lord, the private respondent. Movement history of applicant so and so, applicant Abdul Rakib Boido. First, my lord,
Page
23, my lord.
page 23. Yes.
Page 23, lordship, my lord. First, my lord, 14th of October 2022, fit for inquiry, my lord. Then 15th January 2023, inspector inquiry done. Then, my lord, send back, inquiry done. Next, your lordship sees, my lord, which is important, 15th of March 2023. The applicant complies GO 1706 but does not fully comply 1707, as in spite of having my lord, shop come go down 777 square feet, he does not have a shade in front of the shop to accommodate a queue. So he is eligible but not recommended. But I say ineligible, but anyways, my lord, not recommended. Then, my lord, next is, my lord, he's given 20 marks. Because he's given 20 marks by the state, my lord, district level, my lord, again, it is sent back, my lord, and then, my lord, he is recommended. 20 marks, my lord, therefore recommended, because he gets the highest mark. Next, lordship sees, as the applicant has proposed a shop come go down without shed for the consumers, district level may be requested to reassess its decision. So, district level, my lord, because of this eligibility criteria not having been fulfilled, my lord, it is sent for reassessment, my lord. They reassess and say, my lord, the applicant has fulfilled required criteria except classification of land, which, my lord, is an incorrect understanding of law or an incorrect understanding of facts vis-a-vis the notification. So the district level, my lord, says that no, they have fulfilled all the required criteria, which is incorrect. They did not. Now, conversion, then, my lord, also see, my lord, except classification of land, conversion of which has been applied. Again, because they were misled into thinking that yes, there is an application for conversion, my lord, therefore they come to the conclusion, okay, he can be recommended. Although I say, my lord, that this, my lord, relaxation with regard to conversion, my lord, the notification only came in 2023. This notification is of 2022, my lord. So even this did not apply. The relaxation could not have been given.
Yes.
And therefore, if your lordship sees, my lord, it is only on the basis of the conversion or the application for conversion, my lord, he has been recommended. And if your lordship has any doubt in your lordship's mind, lordship will ask my learned friend, my lord. Perhaps, my lord, it will, my lord, satisfy my conscience as well. That yes, the application was made sometime in September 2022.
Name of the petitioner is Abdul Hakim Molla.
Yes, Lord.
So you have got the marks.
Oh, yes. If your
The
lordship
nature of possession only 8.
Yes.
Only this change.
Only
He
this change, my
got
lord?
10.
Yes, he got 10.
You have the legal right and he has the ownership.
Correct.
That's why 8 and 10.
8 and 10.
And what about 3 and 2 marks for category of applicant?
I am OBC, he is general.
You are OBC category, he is general.
Is general.
Okay.
So 1 marks there. But all this, he could not have, my lord, reached this stage had the applicant, my lord, disclosed, my lord, everything truthfully before the inquiry officer.
Okay.
And I have shown your lordship, my lord, the application was actually made for conversion on 22nd of June 2023, which is much after notification, much after the application, much after the date of inquiry.
Yes.
Well, that would be all, my lord, and once again grateful to the state, my lord.
My lord, my learned friend has not answered about the maintainability. So maintainability is to be decided first, then after we can go into the merits. If your lordship
He
is
has
satisfied-
argued that he is the eligible candidate, not ineligible candidate. So he can question your eligibility.
No, my lord, I beg to differ.
Yes. This is
First of all-
his only answer on
First
your,
of all, he has not challenged his rejection. I have shown the division bench judgment.
yes.
Until rejection is challenged, it is not maintainable.
He has not challenged in the writ.
Yes, rejection order has not been challenged. Kindly see the prayer.
What is the prayer?
Prayer for cancellation. Let me, my lord, go through. Mandamus be issued commanding the respondent to act in accordance and to appoint the petitioner as FPS and award appear dealership in his favor. Without challenging the rejection, he is seeking appointment. Next, my lord, Mandamus, quashing of my appointment, not quashing of his own rejection of candidature. There are two Mandamus. So petition in itself is not maintainable, madam. That is my first point I have taken for lordship.
Yes.
So until he replies to this maintainability point, he cannot argue on the merits.
That
Mr. Agarwal, what about the merit? You can argue. I shall pass the order in respect.
Yes, I shall argue on merits also. But if your lordship is satisfied, first of all, that if maintainability is taken into consideration and he is not
I will
entitled
take
to-
up the matters, no issue, but I want to hear the maintainability and
Yes,
also
then-
the merit.
Yes, my lord, I am ready for maintainability also, my lord.
Merit, yes.
My learned friend has shown, your lordship, page 25 of the report. That this is not an application because there is no seal signature of any person. But your lordship will kindly see the date. There is not only date, but some signature is also there, my lord. I have marked it here, my lord, with highlighter.
Yes.
There is the signature of the recipient. There was a stamp. So this application was filed before the date of application. Now, my lord, second one, why the conversion order is of dated 22 June 2023? Because of the fact that this application was made not in the proforma, actual proforma. That's why they wanted me to file another application, which was filed on 22nd June 2023. And your lordship will kindly peruse this marking at page 23.
Yes.
So, my lord, your lordship will appreciate that second application is in continuation of the first application. So the application was already made before the application filed.
Yes.
Now, my lord, kindly come to page 23. My learned friend has shown your lordship page 23.
Yes.
The applicant complies 0176 such and such. He does not have a state. That was not the correct inquiry report. That's why it was reassessed. And after reassessment, you will kindly will find thereafter last recommendation, the applicant has fulfilled required criteria except classification of land. Because said was there. Now, my lord, kindly come to my affidavit in a position. The document has been annexed. The photograph has been annexed. I have got the copy. It is in black and white. It is a colored photograph. Colored. I don't know whether it is colored or it is colored or something. Yeah, chill. The shade is
very much there.
दिखाई ना कलर वाला.
देखिए ना भाई. Yes, shade is very much there. That's why upon reassessment, they found that the inquiry report with regard to the shade was not correct. Then they came to the finding that the applicant has fulfilled required criteria except classification of land. Because till that date, there was no classification of land, there was no conversion. But on the date, just before the approval, it came, and that is at page 27. So it cannot be said that that is a cold document or this application was never submitted on 20 September 2022. Your Lordship will appreciate, my Lord, that no government officer is going to record that an application has been submitted without having the original copy of that. And it is in the inquiry report itself that there is, kindly go to the inquiry report, yes, applied for conversion. It has been mentioned, applied for conversion, that is 20 September 2022. And after verification of the original documents, this report is being prepared. Now, second application which was made in continuation of the first application was 22nd June 2023. Yes. So far as my merit of my candidature is concerned, my lord, I have cleared to your lordship that conversion applies was initially made on 20 September 2022, and in continuation thereof, the second application was made on 22nd June 2023, and conversion was allowed. And your lordship knows, my lord, that after offer letter, I have to submit the conversion letter within 3 months therefrom. And my learned friend has taken a point that if that is to be considered, that is the notification of 2022 and amendment came into 2023. Is it so? No. You have said so?
Notification दिखाइए कुछ ना.
I have shown your lordship on the last occasion that notification. Today I have not brought out, maybe your lordship file, that after offer letter is issued within 3 months, I have to submit the conversion certificate. And that was submitted. And that notification was of 2023. There is a judgment your lordship has got, that is a division bench judgment even, that if any amendment is brought before consideration, yes, then the amendment will be treated as if it was available at the time of promulgation of that controller. That is also division bench judgment here.
If it is clarificatory, declaratory.
Yes, madam. And that is clarificatory.
Yes, yes.
In any case, my lord, I am not going on that. I am on the issue that I had already applied for conversion. They have accepted it. The state is the competent authority, your lordship has held in your lordship's own order. No bias has been alleged against the state in the writ petition. And first and foremost thing, the petitioner is relying upon the report of the state. The writ petition should have been thrown out of the court, my lord, subject to your lordship, my lord, when the petitioner did not disclose any document regarding his eligibility. No document has been disclosed that he is eligible. So once he says that I shall rely upon the report of the state in my case, and I shall not rely upon the report of the state in the case of the private respondent. The petitioner is liable, petitioner will have to prove his own case. Your lordship knows better than me, my lord, that a writ petition is maintainable only when the writ petitioner comes with clean hand and proves his own case. Here, he did not prove his case that he is eligible. No documents have been annexed. He did not challenge his rejection order. And he is asking for the mandama to give appointment in his favor.
How his legal right is affected, my lord, I do not know. My lord, I ask myself, until the petitioner demonstrates that from his own documents that he is eligible, he cannot maintain the application. On the other hand, I have shown you on the merits itself that application was made in the year 20 September 2022. In continuation thereof, the second application was made. My learned friend has tried to take benefit of the ineligible copy of this annexer D. But my lord, I have shown, if you also kindly see that after marking, it will show that there is a signature and distance. And if state has accepted this document, my learned friend cannot challenge it. Until, my lord, an arbitrariness is alleged, a bias is alleged, state is the competent authority to see who is the competent one.
Okay. Yes, for the
Yes.
state.
For the state, I say that since I'm representing the state, I cannot go beyond what has been declared in the affidavit.
Yes.
Affidavit is a document which is given on oath. State officers are, I'm not presenting any point of law because here it is a question of fact now. It's question of fact, that is why the affidavit. And I would just bring your lordship notice to page number 14 of the report. The last line, 62, column 62, comments. Documents have been verified. The last line, page 14.
This is report of
The state.
no
On
this
behalf
is
of the state
inquiry
response.
report.
Inquiry report. And after the inquiry report,
Abdul Hakim Mullah.
yes,
This is the petitioner.
yes. Documents have been verified. Other points, submission on points of law, my learned senior has already placed forward, considering that the state will consider what is convenient, inconvenient, because this is a public policy decision. And there is no right which acquires, no legal right which acquires to the petitioner to ask for a relief of mandamus. So every aspect was taken into consideration. The documents are in front of your lordship in the form of an affidavit. The last column comments, documents have been verified with the seal and signature of the verification officer. After this, lordship, there's nothing more that I can bring to your
Yes.
lordship's notice.
That's all.
And one thing, lordship, like whatever the petitioner, his allegation was mainly against the private respondent. The private respondent has defended himself well. The state stands by.
Yes, reply.
Yes. Let me start with the statement because it's a very, it was a short and crisp submission, my lord. My learned friend has, my lord, showed page 14. Lordship, can you come to page 14? Page 14, my lord. 62 comments, documents have been verified. This, my lord, I believe, my lord, my learned friend, my lord, has placed, my lord, to support the case with regard to, my lord, the conversion certificate. With
Yes.
regard to the conversion certificate. Now, my lord, page 14, my lord, is the inquiry report of the petitioner.
I have seen.
Yes. Now, if your lordship turns to page 21. Now, if your lordship turns to page 21 and sees comments in respect of the private respondent, it says documents regarding ownership have been verified.
Yes.
So they become very specific when it comes to, my lord, the documents of the private respondent. Therefore, no other documents, which means not even the conversion application for conversion. It is only and only the documents with regard to ownership that were verified. But again, I'm thankful to the state, my lord, for pointing this out.
All details. Lordship, page 19 then.
I've seen all the report.
Yes, Lordship.
Page 19, our documents have also been verified. All the details.
All the details have been.
Yes,
verified.
yes.
And then the details is with regard to, my lord, if your lordship sees, if it starts reading from 18, my lord, the details are with regard to, my lord, the personal details of the applicant. Details do not mean documents. There's a huge difference between details and documents. Here we are dealing with documents. The question mark is with regard to the document. Now, my lord, with regard to, my lord,
You just see the report. You have not seen the report. None of you have seen the report directly. There are some parts of the report. Part 2, there are some comments. Part 3, there are some comments. Part 4, there are some comments.
Yes.
Part 4, in respect of the private respondent, storage go down office details, it has stated in the command of suitability that the applicant complies geo number such and such, character of land is Sally and applied for conversion.
Documents have
These are the report, pro forma report is that there are parts and after each part, there are some comments required to
Yes.
made by the inquiring officer.
absolutely.
So the reports and the comments are in respect of the parts.
Of the parts, that is what I'm on. That's what I'm, because they said about details, but I said,
No,
this
documents
detail
have
is-
been verified. Documents have been verified in my case also. That is at page
I have seen.
21.
I have seen.
Documents regarding the ownership verified.
documents,
No.
that is what I'm on. Documents regarding ownership has been verified. That is exactly what I'm on, not documents with regard to application for conversion.
It's 2156, 156.
Page
56.
Yes, the applicant complies Geo 17 with character of land.
Shali.
Character of land is Shali and applied for conversion.
Yes.
Because why? Because of the document at page 25. Then Q shed is not available at the time of inquiry. Specific, my lord, it is not available at the time of inquiry. The shed was not there, which is one of the eligibility criteria. You have to pass that eligibility criteria for you to be eligible for the second round. It specifically says so. Is not available.
Yes.
Next, if your lordship comes to page 25 once again, Lord, I do not see any official stamp of receipt. All that I see, my lord, which, my lord, I am trying to decipher is the date, which perhaps is 20/9/22. That is all that I can decipher. If that be so, lordship will kindly call for the records. The original, my lord, it is the application of my learned friend's client, my lord. He will produce the originals. Let him produce it. He is saying that there is a stamp. Let him show where the stamp is. I cannot see any stamp over here. It is so simple and so easy. And when I have taken this specific stand in my writ petition, my lord, it should have been dealt with in the affidavit in opposition.
You have not dealt with this writ petition, this challenge, this matter, this document in the writ petition.
No,
You
writ
have not
petition.
challenged this document in the writ petition. Also,
No.
you have not challenged the document in your reply or exception.
I have, my lord, if your lordship comes to the writ petition first, my lord. If your lordship sees, my lord, kindly comes to page 31. Kindly comes to page 31. Kireni Shali. Lordship now turns over, my lord.
Yes. Page
31, lordship has seen.
31.
Yes. It is my case in the writ petition.
Yes.
Page 31, Lordship sees, my lord, Jomi Srini Shali.
No. Jomi Seni Sali is correct.
Huh.
Everyone is admitted that the classification
Now,
of
Lordship
land
turns over
was
page
Sali.
32. Turns to page 32. This is all that I could lay my hands on, because this, my lord, is available on the website, internet. Lordship sees, my lord, I have said so. Case date 22/5/2020, 22/6/2023. And this is my challenge, that the conversion took place after the date of notification, after the date of application for FPS license, and after the date of inquiry. This is my specific case in the writ petition.
Very well.
Now, Lordship, so far as page 25 is concerned, my lord, we are all guessing. Me, my learned friend, Lordship, everyone is guessing as to what is there on the top right hand side. I can only see the date. My learned friend can see the receipt and stamp of the authority, my lord. And perhaps, my lord, it is left to your Lordship, my lord, until unless the original is produced, my lord, perhaps it is everyone's guess. Next, my lord, which is very important, I say. Now, for the first, once I showed this, my lord, and the date, and my lord, the document at page 27, which specifically mentions the date of application for conversion, my learned friend, my lord, from the bar today says that no, this application that was made was not in the correct pro forma. Therefore, we made a second application, and the date of the second application is mentioned. My lord, this case is not there in their affidavit in opposition. Not there. Not a word. The private respondent should have come with clean hands if this was their case, because it is the specific case that I have taken. In my writ petition, I have taken a specific case that your conversion was much after the date of inquiry also. Nothing. Lordship will see the entire affidavit in opposition, my lord, not even a word. In fact, they do not even mention the date of the application in their affidavit in opposition.
Okay.
So, my lord, nothing on affidavit for the first time from the bar. Not so far as the shed is concerned, my lord. Lordship has, in fact, Lordship has pointed out, my lord, that the report, the inquiry report of the private respondent itself says, my lord, that there is no shed. Now, the photographs that my learned friend has shown, my lord, perhaps he's made the sheds now that he's got the license, he's made that shed. But even that shed, if your Lordship sees, my lord, cannot accommodate 20 people from the photograph itself. But it is not about the making of the shed, my lord, constructing the shed now. The shed ought to have been constructed, ought to have been there at the date of inquiry. And the inquiry report says that there was no shed, which your Lordship has pointed out, which I also missed, but your Lordship has seen. Another point that my learned friend took, my lord, that I have not said in my writ petition that, my lord, the action of the state is arbitrary. Lordship will kindly take paragraph 14 of my writ petition, 14 and 17. The petitioner states and submits that the said purported license has been issued illegally, arbitrarily, unjustly, unreasonable, and in a manner violative of the principles of natural justice, equity, and good conscience. The petitioner is eligible and most suitable to be granted the FPS dealership. I have said so. In fact, in paragraph 17 also. No hearing was ever granted to the petitioner, my lord. As such, the petitioner authorities have acted in violation of the principles of natural justice, equity, and good conscience. I have taken this specific point.
Whether hearing was conducted in respect of the private respondent?
This I do not know. How
Then
can I know, my lord? Only
It
the
is not
state will.
obligatory, it is not mandatory that all persons should be.
No, not mandatory.
Then-
Not mandatory. Not mandatory. If it has happened, if he has been given a hearing and I have not been given a hearing, my lord, then that violates.
Yes. So you have not said that the private respondent was also given hearing.
No,
You
I
have
have
not
said
given
about
hearing.
myself that no hearing was given to me. But if your lordship sees paragraph 14,
Yes.
paragraph 14, it is specific.
Hmm.
It is about the grant of license. It is about the action of the state in granting the license. I have said so.
Very good. That's
Now,
all.
my lord, so far as the notification, my lord, that my learned friend just spoke of, my lord, perhaps, my lord, that has not seen the light of the day, my lord. May I, if I get a copy of that notification that my learned friend is talking about, my lord, perhaps, my lord, we'll be able to make our submissions, my lord. And my lord, if my lord, as I could gather, my lord, from the submissions made by the state and the my lord, the private respondent, this my lord, it is as if, my lord, if the state grants a license, it cannot be challenged. The action of the state cannot be challenged. It cannot be so. It cannot be so. The action of the state is always susceptible to challenge if the action taken is contrary to law, contrary to principles of natural justice, and violates my
Yes,
fundamental.
always it is true.
Yes. And Mr. Agarwal does so every day, but today he says that
No, no, he is
I
not
cannot.
saying so. He is not saying so.
I am saying only that he will have to demonstrate his eligibility
My
and action-
eligibility has been demonstrated by the state itself.
and action
The
of the
state which
Only
gave
one,
license.
one argument Mr. Agarwal has thrown that
Yes.
you have not challenged your rejection.
Lord, I have been held to be eligible. What will I challenge? I have already been held to be eligible.
You have not challenged your rejection in this writ petition.
Need not.
Yes.
I need not, my lord. Why I say so, my lord? Lordship will kindly take my praise. B. Writ of mandamus, my lord, and may be issued commanding the respondents and each of them to act in accordance with law and to appoint the petitioner as FPS dealer and award the FPS dealership license in respect of the FPS shop. Lord, therefore, the reason that I have been held to be eligible, the only issue is with regard to the marks if the state is concerned. Had I been, my lord, had my application been rejected for being non-eligible, then I would have challenged my non-eligibility. Here I have been held to be eligible. What will I challenge?
Lordship, on behalf of
And
the
Lordship,
state,
I will, my lord, I can produce 10 judgments. In fact, judgments filed by Lordship, my lord, in my case was my lord, Regia Pervin's case, my lord, where your Lordship remembers, my lord, same stand was taken by the state that the writ petition is not maintainable, my lord, and your Lordship has held that it is maintainable because at all stages the petitioner has been held to be eligible.
Yes.
Lordship has held that in Regia Pervin's case.
Lordship, on behalf of the state, I would like to draw your Lordship attention
Lord,
only on
like to
paragraph
reply, my lord.
6, 7.
Anything you have to?
That is it.
Yes.
Paragraph 6 and 7. He is saying that we have not, like there's arbitrariness, there's bias, there's violation of natural justice. Paragraph 6 very clearly, if I may read, Lordship, after receiving the applications in response to the said advertisement for FPS dealership, a field inspection and spot enquiry was conducted. Date is given. The said team thoroughly inquired the applicants in respect of the nature of land, area of land, condition of go down, storage capacity, financial solvency, and other criteria which are necessary for selection of new fair price shop dealers. It is specifically mentioned herein that after conducting a
Yes,
thorough
yes.
inquiry by the
Let that,
inquiry
my lord.
team,
In fact, I started
and
with paragraph
Lordship, since he also is saying that we have not, taken the respondent into consideration, the private respondent into consideration. On the other hand, paragraph 7. On the other hand, at the time of inquiry, it was found Abdul Rakib. Now, it is also mentioned that the petitioner's place was on rent, whereas the private respondent's
yes.
was on ownership.
It was not checked.
The shade, how many people could be accommodated, whether there was adequate space in front of the go down for unloading, loading and unloading of food grains. Everything was taken into consideration before this report was filed, Your Lordship, with the affidavit.
Okay, my learned friend has not shown your lordship that the state was biased against it. Your lordship has held in your lordship judgment in Pushpa Begum that no bias has been alleged against the state. What has been stated that the action is arbitrary, but state authorities are biased against it.
Why
Right.
will I say
That has
that?
not been alleged.
Why will I say
And
that
your
the state is
lordship-
biased? my lord?
Okay,
I have said that it is arbitrary because the notification itself was not considered, my lord, the eligibility
I
criteria
understand.
and the conversion.
I understand.
That is the arbitrary
Let
nature.
the petitioner
Why will
then
I say
first
biased, my
produce
lord?
his
No
own
representation
papers,
has been given to the state.
his own
That-
papers supporting his case.
It does not
That
lie in the
how
mouth of the
these
state,
two
my
are
lord, when they've held me to be eligible.
Very hard.
শেষ হয়ে গেছে তুমি এসে বলতে চলবে শেষ হয়ে গেছে
Okay, please take down.
May I, my lord, take a lordship's leave?
Yes.
His present status to record.
Subdivisional controller, food and supplies. Baruipur. Issued a vacancy notification on 10th of June 2022 in respect of an FPS dealership at Mouja Dara, Gram Panchayat Jagulgachi, block Bhangor 1, Baruipur, South 24 Parganas. Full stop. Petitioner, private respondent, petitioner, private respondents, and others has applied for the vacancy. Full stop. The state respondents, after complying formalities, has selected private respondent number 6 to be an eligible candidate for the vacancy of FPS dealership. Full stop. Petitioner challenged the said action of the state by filing the instant writ petition. Full stop. Next para. The private respondent has challenged the writ petition on the ground that the writ petition is not at all maintainable. Mr. Agarwal, appearing on behalf of the private respondent, submits that the petitioner not challenge his rejection of FPS dealership by the authority. Thus, the instant writ is not maintainable. He also argued that the present petitioner is not an aggrieved party. No legally protected right of the petitioner had been violated, so the instant writ is not maintainable. Next para. The petitioner argued that the writ petition is very well maintainable. He challenged the action of the state authority in respect of appointment of the private respondent in the said FPS dealership. He further submit that the petitioner is an eligible candidate. So if the candidature of the private respondent was appeared to be কি বললাম? So if the selection of private respondent appeared to be an arbitrary action of the state authority, the present petitioner would automatically be eligible or fit to be appointed for the said post, for the said vacancy, He further argued that petitioner was always a eligible candidate, so he has every right to challenge the action of the state in a writ petition, which would prove that the selection of the private respondent for the said vacancy is not only arbitrary but also a malified and biased action of the state.
My lord, bias action has not been there. Yes, no,
He has not said
only arbitrary.
only arbitrary.
Yes, I'm not saying
Arbitrary and
bias.
malified action of the state. Very well. Okay. Verified. Vast action of the state. Malified. Arbitrary malified action of the state. Having heard the learned counsel for the parties, it appears to me that the instant writ petition cannot be decided on the point of maintainability, as the point itself involved the facts of law as well as the facts of as well as the points of law as well as the points of fact itself. So without deciding the facts of the instant writ petition, the writ petition, it cannot be disposed of on the point of maintainability. On that score, I intend to hear the writ petition on merit. Full stop. Next, learned counsel for the petitioner submits that the private respondent as well as the petitioner has applied for the vacancy by specific application. Full stop. The report of the state would reveal that after receiving such information, after receiving such application, the state authority has conducted the inquiry over the proposed shop-cum godown of the private respondent as well as the petitioner. He submits that the report of the state authority would reveal that at the time of inquiry, private respondent had no shed in front of the proposed shop room. He further argued that the report will also reveal that the character of the land of the proposed shop-cum godown of the private respondent is Sali, Shali. He argued that on the to score, the private respondent is an eligible person, is an ineligible person. He referred the eligible criteria of vacancy notification dated June 10th, 2022, wherein it has been mentioned that within inverted comma, there must be a shade in front within inverted comma. There must be a shade in front of the shop to accommodate at least 20 people. Close. Inverted comma close. Learned counsel for the petitioner further argued that the petitioner, private respondent was an ineligible candidate, so his report cannot be forwarded to the district level fair price shop selection committee in terms of notification dated 17th/8/2021. Full stop. He further submits that the state authority has arbitrarily forwarded the report of the private respondent to the district level fair price shop selection committee for taking final decision. He again argued that the classification of land at the time classification of land of the proposed shop come go down of private respondent was Sali at the time of inspection. The report of the state mention one conversion certificate which disclosed that private respondent has applied for conversion on 22nd of June 2023. The inspection was held on 28th of October 2022. So it proves that at the time of inquiry, the private respondent never applied for conversion of the classification of the proposed shop come go down, proposed land used for shop come go down. On the above score, the learned counsel for the petitioner submits that the action of the state authority is arbitrary in appointing the private respondent. Thus, the appointment of the private respondent for FPS vacancy is liable to be quashed. It is a further case of the petitioner that he is the most eligible candidate and he has complied with all formalities according to the specification of the vacancy notification. Thus, he may be granted the license of FPS vacancy. FPS vacancy. FPS dealership. FPS dealership. Which Mr. Agarwal, learned counsel appearing, senior counsel appearing on behalf of the petitioner, behalf of the private respondent submits that from the inquiry report, it would be revealed that private respondent has applied for the conversion of the land much prior to the date of inspection. He placed a document from the report of the state at page 25 that private respondent has applied for conversion on 20th of September 2022. 20th September 2022. That is much prior to the date of inspection. He further submits that in the report, the inquiring inspector has noted down that the petitioner has applied for conversion. He further submits that the report of the inspector, if taken to be true, then it has to be considered, it has to be proved that private respondent has applied for change of character of land prior to the inspection. Mr. Agarwal submits that the certificate of conversion, which disclosed the date of application, dated 22/6/2023, is subsequent date for filing pro forma application with the concerned department. It is the argument of Mr. Agarwal that he applied for the conversion on 28th September 2022, but subsequently, according to the according to the direction of the concerned department, he applied with pro forma on 28th June 2023. It is the further submission of the Mr. Agarwal that the authority concerned has considered the applicants, considered the candidatures of private respondent as well as the petitioner in its true letter and spirit, and after final decision, after verification of candidatures, it appears to the authority that the private respondent is most eligible person. Thus, they have selected the private respondent to be fit for granting license of FPSC. They submit that the authority concerned is a expert. So expert, and the petitioner has not demonstrated any biasness or favorism of the authority concerned in deciding the case of the private respondent. So the action of the authority in appointing private respondent to be most eligible candidate cannot be called into question in this writ petition. Full stop. Learned counsel appearing on behalf of the state authority has placed the report and submitted that the concerned authority has verified the applications of each and every applicants. The inquiry team has conducted the inspection at the proposed SOPCOM godown of every candidates, and they have system generated marks for eligible candidate according to the notification dated 17 of August 2021. In such system generated marks, the petitioner has obtained 69 marks out of 75, and the private respondent has obtained private respondent has obtained 59 কত বললাম 59 বললাম 59 marks 59 marks and private out of 75, and private respondent has obtained 60 marks out of 75. Full stop. Thereafter, the matter was placed before the district level fair price of selection committee for awarding marks out of total 25, wherein the district level fair price of selection committee has awarded 20 marks to the private respondent and 19 marks to the petitioner. In total, out of private respondent had scored 80 marks, whereas the petitioner has obtained 78 marks. It is the case of the state authority that as the petitioner became scored highest, so he has been selected
The respondent.
for the said vacancy.
The respondent. The private respondent.
Highest marks.
Not the petitioner.
Not the petitioner, just not
Private respondent.
Private.
কি বললাম? Private respondent? No, private respondent's code has mark. As the private respondent code has marks, for the vacancy, said vacancy, full stop. Learned counsel for the state authority also place the notifications and the core sheets of the petitioner as well as the private respondents. The state respondent has also placed the movement history of the private respondent in selecting him to be the most eligible candidates. Full stop. Learned counsel for the state authority further submits that the state has not acted arbitrarily in selecting the private respondent number 6 to be the most eligible candidate. They have acted according to the notification and according to the law. So the writ petitioner is not writ petitioner being not the highest scorer of the said mark-based system, he is not entitled to get the vacancy, license of the vacancy. Having heard the learned counsel for the parties, also considering the report as placed by the state authority, as well as the question raised by the petitioner before this court, it appears to me that during the course of inquiry at the proposed shop-cum go-down of the petitioner, the inquiring officer has correctly observed that the land of the proposed shop-cum go-down of the private respondent was Sali. He has mentioned that the private respondent has applied for the conversion. He has also mentioned in the report, inspector has also mentioned in the report that Q said is not available at the time of inquiry. Full stop. In overall comments in respect of the inquiry report of private respondent, the inspector has observed within inverted comma, apart from Q said and conversion of character of land within bracket for which already applied bracket close, comma, for which already applied bracket close, comma, the applicant may be fit for recommendation. Full stop. It is the case of the petitioner that the private respondent had no Q said in front of his shop room, so he is not an eligible candidate. Full stop. It appears from the notification dated 17/8/2021, wherein the state has formulated a score-based system for appointment of FPS dealers, comma, the score-based system never mentioned regarding the existence of said. It has mentioned about the nature of land and nature of possession of the land and others. The presence of said over the proposed shop come go down is maybe the eligible criteria according to the notification, but in deciding the candidature of a candidate, the state has to obtain certain formalities in terms of notification dated 17th August 2021. The said notification did not discriminate a person, a candidate having said and a candidate having no said and a candidate having no said in front of their shop rooms. Full stop. The petitioner may raise a question that the private respondent is an eligible candidate, is an ineligible candidate, but in deciding such issue, the state authority has adopted the score-based system according to the notification dated 17th August 2021 and forwarded the candidatures and their inquiry reports to the fair price sub district level fair price sub selection committee. The district full stop. The said committee has observed the entire report and has awarded 20 marks to the private respondent and 19 marks to the petitioner. Full stop. The private respondent has obtained 2 marks more only in respect of nature of possession of the land. Full stop. After observing the movement history of the application of the private respondent, it appears to me that after the inquiry, the authority has pointed out that private respondent is an eligible candidate but not found most suitable. Such report was placed before the district level fair price sub selection committee, who scored 20 marks out of 25 to the private respondent. The district level committee has also recommended the private respondent to be eligible candidate. Full stop. In spite of the deficiency of said in front of the shop come go down, the district level fair price sub selection committee has recommended the private respondent to be a fit candidate for giving the license. Full stop. The read court, next part, the read court is not within the domain to determine the entire eligible criteria and every materials thereon and to scrutinize the suitability of a candidate. Full stop. It is the appropriate authority, comma, who is the most experienced authority to select a successful candidate for distribution of food grains at the locality. The writ court is only to authorize, only to decide whether the act of the authority is arbitrary, malified, or any favorism or biasness was attributed by the authority at the time of selecting a candidate. Full stop. The merit of the determination of a candidate's merit of scrutiny by the authority cannot be challenged in the writ petition. Only the procedure of the selection can be challenged. In this court, I am of a view that in spite of certain discrepancies, the authority concerned has selected the private respondent to be the eligible and fit candidate for giving the license. The full stop. The petitioner may have demonstrated a case that he is the most eligible candidate, but the district level committee has selected the private respondent to be most eligible candidate. The biasness as alleged by the petitioner has not raised any question of biasness. Against the state authority. Full stop. Furthermore, on perusing the score-based system, it appears to me that the petitioner has only given 1 mark less in respect of selection of the 1 mark less than the private respondent by the district level fair price of selection committee. Under the above observation, I am of a view that the authority concerned has not acted illegally or arbitrarily in deciding the private respondent to be the most eligible candidate. In that score, the instant writ petition is disposed of. I find no justification to interfere. Sorry, in that score, I find no justification to entertain the petitioner. Accordingly, the instant writ petition is dismissed and disposed of.
Grateful, Lordship.
Grateful, Your Lordship.
I wish I could see this.
Thank you, Your Lordship. I am appealing for the petitioner. I am praying for that let the matter be released from this list, Your Lordship. The matter
No.
pertains to Group 8, Group 9 matter.
The question is that the foreign liquor doesn't fall under the group of the
Wrongly.
essential commodities.
Wrongly
So it will go
filed, Will.
to the for the some people, not for the all.
Very well.
Wrongly
Please
filed.
take down. Let the matter be released.
কি বলবো
লাগবে for want of determination. আর কিছু না।
the বিভিন্ন
There was a direction,
डायरेक्शन
हाँ, to file affidavit. Copy তোমাকে দিয়েছে?
नहीं ये दूसरा वाला है ये तो आज फर्स्ट टाइम हो रहा है
Lordship, it is with 255. देखो, it is 255. Yes.
Report in the form of affidavit.
oh that is
Yes,
because
yes.
the notification was not
Yes.
This, my lord, I have challenged my lord, notification matter, my lord. My lord, when I had filed the writ petition, my lord, I did not have a copy of the notification. So, the state, my lord, lordship directed the state to get a copy of the notification. Yes,
Okay, or notification dated 18th of October.
yes, my lord. So, I'll be, my lord, praying for this usual order, my lord, that your lordship passes.
I had handed over.
And my submit, my lord, in another case, my lord, she had also handed over a
Yes.
copy of the notification. Yes, she had. And I do have it with me now.
দেখো তোমার থেকে বেশি আমার মনে আছে
Lordship may pass, my lord, the usual order.
Where is your license?
License, your lordship will find, my lord, at page 22, my lord. Sorry?
Page 22.
Yes. And my lord, representation, lordship will find, my lord, at page 31, my lord.
It is a license in respect of Mauja Nahar Gach is the vacancy.
Dutch.
আর গাছি
Nahar Gach. Daspara. Are you distributing food articles on that location?
Lordship. Which is mentioned in paragraph 1 of my report.
Paragraph?
Paragraph 1.
Paragraph 1.
And the pleadings are all the same, my lord, as in other matters, my lord.
Nahar Gach.
Yes.
Nahar Gachi or Nahar Gach?
গাছি your lordship what I can
Should be Gachi, but in the notification,
Notification
it
is a
Gachi.
Nahar Gach.
but in our affidavit we have written it's Nahar Gachi.
Okay. আগে নিয়েছেন এগুলো মনে আছে? ভুলে গেছেন? একই রকম নিয়েছিলেন অনেকগুলো। ভুলে গেছেন।
Next may Vihoti. Next to
আপনার কাছে আছে? আমি বললাম
मेरा सब लोग
আছে তো আমার কাছে।
अलग अलग कोर्ट में बैठे
দেখছি, হ্যাঁ।
इस वीक कुछ ज्यादा
তাহলে
ही
বলতে হবে আবার। আমার বলতে হবে। আমার তো মনে থাকবে। আমি বলে দিচ্ছি। নেই।
पहली बार आ रहा है
তাহলে আপনাদের সুবিধা দিয়ে দিন।
नहीं,
आ चुका है
আচ্ছা। বলে দিচ্ছি।
क्या नाम है?
The other one is also affidavit of opposition.
Chandan Goswami is ours and बच्ची
क्या उसका?
वो तब सिर्फ संन्यावाल होगी छोटी
The report in the form of affidavit filed by the respondent number 124 is taken on record. Report in the form of affidavit filed by the respondent number 124 is taken on record. It appears from the report that the SCFS Islampur has issued the notification
Sorry, sir.
for issued a vacancy notification on 18th of October 2022 for filling a vacancy of FPS dealership under WBPDS Maintenance and Control Order bracket close 2013 at the location Nahargach NAHRGACH এটা একটু বোল্ড করবে wherein the present petitioner is running a FPS business since long without any complaint. Full stop. it is the case of the petitioner that after promulgation of National Food Security Act 2013 and targeted public distribution system within bracket control order 2015, comma, the WBPDS within bracket M and C bracket close orders 2013, on the basis of which the instant notification was published, has become redundant. Full stop. Learned Counsel, Mr. Aptauddin, also argued that the same issue, the issue which is raised in the instant writ petition was also raised in a batch of appeals before the learned division bench, being MAT 1543 of 2023. MAT 1543 of 2023. Full stop. He submits that till the disposal of the said appeals, said batch of appeals, the authority concerned may be directed to stall the procedure for selection of the new FPS dealer. Full stop. Learned Counsel, appearing on behalf of the state authority, has raised strong objection and submits that issue involved before the Honorable Division Bench is not similar to that of the issues raised in the instant writ petition. Full stop. Having heard the learned counsels for the parties, comma, state is directed to submit a report in the form of affidavit within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Considering the facts and circumstances of this case, and considering the issue that, considering the matter that similar issue was pending to be determined by the Honorable Division Bench in MAT 1543 of 2023, and also categorize the matter, also categorize the issue that the Honorable Division Bench has already issued an interim order in that appeals, in those appeals, comma, I am of a view that, comma, I am of a view that question, comma, I am of a view that the present petitioner also deserve the similar interim order. Under the above observation, the state authority is directed, is at liberty to proceed with the selection process of the impugned vacancy notification, but so far as the appointment of new dealer is concerned, the same shall not be commissioned to in favor of any person without the permission of this court. Okay. Let the matter go out of the list. Parties are at liberty to mention. The report filed in behalf of the respondent 1 to 4 is taken on record.
Private respondent আমার বলার আছে অনেক। হ্যাঁ বলতো তো main respondent.
My lord, I am for the private respondent number 6. I am challenging the locus of the petitioner and maintainability of the writ petition.
Yes.
Let my friend.
Who is for the state authority?
Mr. Bandopadhyay and Mr. Ganguly Milord are appearing on behalf of state authorities. Milord, we have filed a report But my lord, the original copy of the report, my lord, has somewhat been misplaced during the vacations, my lord. Kindly grant us 2 more weeks, my lord. We will reaffirm it. We have filed and we have served, my lord.
Positively, my lord.
Have you received the report?
No,
What is the
I
report?
have not received any report.
I'll serve my learned friend as well. My lord, the original, my lord, will file within 2 weeks.
Sorry? No. We last occasion adjournment was sought for.
Yes, my lord, we have to reaffirm this report, my lord, with sir.
Or, my lord, if Lordship told us, my lord, that I am not disputing anything, this can be reconstructed, my lord. If Lordship told us, because otherwise it will waste court's relevant. Because I have a copy. I have a copy.
Next week? Within next week, it will be possible.
My lord, my lord, the report, my lord, the officer is in Outreach or Dinashpur, my lord. Kindly can.
In the next week, 3 days courts are there.
So I want to know what time you require for reconstruction.
For reconstruction, my lord, it can be done in 2 days. Because I am not
As
disputing.
you serve the matter, let it reconstruct.
My lord, if your lordship so please, my lord, we will
Come
reconstruct.
next week?
With an advance copy to us, we have not
My lord,
received.
we will serve it today only.
Okay.
We will serve it today only.
Learned
supporting
counsel
the
appearing on behalf of the
private
state
scholar.
submit
My
that
report is
though
supporting.
the report in the form of affidavit had served upon the petitioner, but it was misplaced. On hearing that submission, the state authority, the learned counsel appearing on behalf of the state authority is directed to reconstruct the affidavit and serve a copy of the same to the private respondent. Let the reconstructed report be filed within a week. Let the matter appear in the list on 27th. 27th.
My lord, one thing, my lord.
28 হলো অসুবিধা আছে
29. 29 is a Wednesday.
28
29 is Lordship takes a break.
So what did you want? 29?
29
Okay, 29. Okay, very
Very well.
29.
29
Great.
এটা একটা ছবি তুলে নাও নিয়ে এটাকে ছবি তুলে নাও
23. Not today. 24.
হ্যাঁ দিয়ে দিচ্ছি just এক সেকেন্ড ছবিটা
রিপোর্ট দেওয়ার কথা ছিল না দেবুদা রিপোর্ট যেটা এসছে নট স্যাটিসফ্যাক্টরি একদিন টাইম দাও পরবর্তীতে না আন্ডারটেকিং আমি দিতে পারবো শুধু রিপোর্ট ফাইল
Page 23 is the vacancy decline notice.
Whether report filed?
No,
Well, I just tell you, Lordship, my report I have received. But so far, my understanding, Millard, the report is very short. I need to be elaborated the same, Millard, because what I have find, Millard, the credentials or the eligibility criteria of the petitioners, so far the godowns are concerned, which is not falling under the same measure. So
Whatever may you submit the report?
I will definitely, Millard, but the report is not satisfactory to me. How can I file it before this court? This requires some elaborations because what is happened to the ultimately to this, Millard,
2
this
days.
vacancy,
You want 2 days?
2-3 days.
2-3 days.
on last occasion I prayed for an injunction not to declare vacancy. Some protection may be given.
No, Millard cannot be given because he is not falling under the Millard same measure. So Millard, he cannot Millard ask for any injunction.
I shall rely on
Lordship, see Millard, the whether he has any locus to that.
File the report.
Certainly, Millard, certainly. Certainly.
Same subdivisional controller affirm and affidavit in other matters saying that distance is not required, distance is immaterial because today,
No, he has said that you are on other measures.
Yes, that is what I'm saying.
to your lordship, one state highway, this side is one moja, that side other moja. Same location, same place. There is not
Mauja
consideration
means
as the
for
distance,
different location, I think.
not different location. Post office, everything, panchayat, everything correct. So far Mauja is concerned, there is a road. This side are one Mauja, that side are one Mauja. It will not make inconvenient to the consumers. But because the consumers are in both sides,
Whether any vacancy was declared?
they are going to declare vacancy. They have intimated me. They have intimated me. Kindly see on RTI application, they have intimated me. That is page, my lord. 43.
Very today we are in Tuesday. Come on Monday then.
Very well, my lord.
Interim status quo may be right.
No, cannot be, my lord. I am opposing that. What
For
locus he
7
has?
days, how?
They have opposed the same on the last of.
No, I am opposing 1 second, my lord. I am opposing 1 second.
You have given the time, you are not
No,
performing.
no, it is not required, my lord.
No, you are saying that on the Monday you will submit the report.
Definitely, my lord. Report is ready. If your lordship grants me 5 to 3 minutes time, I can file the report. But the report is very short. That is what I am saying.
Okay.
5 to 3 minutes time, my clerk will bring the report. 5 to 3 minutes. But I mean, Sombar raki na.
Okay. Very well. Please take down. On the prayer of the private response, on the prayer of the
State
authority, the matter be adjourned today. Let the matter appear in the list on 20th of January.
My lord.
The state is directed to submit a report positively on the date fixed.
Positively.
Positively.
একটু পাঠিয়ে দিত আমাকে ভাই
ভাই
এটা জুনিয়রটার নাম দিবি না অমৃতা বাজামন
There is the case file is 56. Exhaustive application has been made out by the facts of the case. The father or grandfather.
You take the mic. I cannot hear.
The grandfather of the petitioners was the emergency. Now, after he died, then the vacancy applications was created by the district controller food and supplies, whereas there is no any sub-regional controller. Only sub-regional controller as well the district controller within the district, even prior to 83. Now the applications was applied by the mother of the petitioners along with the others. Now ultimately mother of the petitioners was selected. Then
On compassionate ground.
On compassionate ground. Now he has been directed to the sub-regional controller to give appointment as an MR dealership. Now ultimately that applications has already been considered by the sub-regional controller, but so far the concerned Sabapati as well as the BDO, they some bias has been taken out. Then accordingly her applications was not considered, even not given appointment.
When it was not
Ultimately, the mother of the petitioners come before this honorable court by filing a writ petition. Now on that writ petition, civil rule was issued. Now ultimately that was also not
issued directing the authority to give appointment.
Already it has been directed by the court that issue
What
the
was the
appointment.
direction on that order? Where is that?
My lord.
What is the direction of that order?
My lord. If your lordship kindly see below the page 41, that is on 22nd August 1984, there is a directions of my lord Justice Ajit Kumar Sengupta as his lordship then was.
Page 41.
Page 41. This I am relying of this my lord because the CR number, yes, my lord the cause title. Then an application for continuous violations of the order passed by Lordship the Honorable Justice Ajit Kumar Sengupta on August 22, 1984 by supplying the MR commodities to Ajit Kumar Singh, the restaurant number 10 in the manned rule by the Sub-Regional Controller of Food and Supplies, Raipur 2 Block, Saranga District, Bankura, the response number 6 in the above rule. Now, ultimately, now Aditya Kumar Singho was not the considerer of that application, but he was given appointment without any findings
Where is
of
the
that.
order?
Well, that application, that writ applications has not been supplied by my client. Ultimately, your lordship kindly see the page 2007 in the writ petition subsequently, page 54. 54.
Yes.
That is 8th August 2008. That the petitioner's grievances is over the rejections of her applications for grant of license for appointment, so modified ration dealer. The
Who is the
original
petitioner
application.
there? You are the petitioner there.
No, I was the petitioner is the son of the earlier petitioner.
In
The mother of the petitioners was applied.
7579.
Yes, 2007. There is the mother of the
Parvati Singho was the petitioner.
Parvati Singh.
Parvati Singho was the petitioner.
Parvati Singh.
Parvati Singho was the petitioner.
Yes, Parvati Singh.
Yes. Parvati Singho is your mother.
Is your mother.
Is your mother.
Now he was moved. Lastly, this order was passed on 8th August.
Yes, read out. What is the order?
The order was there. The petitioner's grievance is over rejection of her application for grant of license for appointment as modified ration dealer. The original applications was made in the year 1984, and the petitioners had approached this court in the year 1984 by filing a writ petition, which was disposed of by an honorable single judge of this court on 20th April 2000, directing the Sub-Regional Controller Food and Supplies Department at Bankura to treat the writ petition as representation of the petitioner. The said authority was directed to consider the same in accordance with law. It was also specified in the order that in the event it was found that the petitioner fulfilled all the criteria, the authorities were to take steps for delivery of MR commodities in favor of the petitioner. Such exercise was directed to be completed within a period of 4 weeks from the date of communication of the order. Such representations was considered by the Sub-Regional Controller Food and Supplies Khatra Bankura, and by an order passed on 18th September 2001, the petitioner's application was rejected. It appears that the petitioner has applied for a review of this order, and at this stage, the petitioner's prayer is for a decision on the application for review. The case of the petitioner is that she was given an opportunity of hearing by the said authority, but no decision has yet been taken. Mr. Chakraborty, learned advocate appearing for the respondent authorities, submitted that there is no scope for reviewing an order passed by the Sub-Regional Controller, which is passed on the basis of an order of this court. His further submission is that the application for review was also made after 6 years. Having heard the learned advocate appearing for the parties, I am of the opinion that in the absence of any statutory provision, a statutory authority has no power or jurisdictions to review its own decision. At best, such authority can correct an apparent error of clerical or arithmetical in nature in the order. In the present case, since hearing was given to the petitioner, I am of the view that such authority should examine the applications for review only for the limited purpose to ascertain if any error of clerical nature has crept into the order passed earlier. If such error is found, then a decision shall be given. If such examination does not reveal any error of such nature, the petitioner shall be informed in writing that her representations cannot be considered. The communication in this respect must be made within a period of 4 weeks from the date of communication of this order. With this direction, the petition was disposed of. Ultimately, during this the considerations of the representations, the authority did not take any step. Now, ultimately, she died. After died, I made an application. That is page 56. That was kept pending. Elaborately, I have already stated in my representation. 56, 57. Received that is 61. Delivery confirmed. 23rd August 2024.
When the representation has been made?
That was delay because there was some delay.
You must bring.
But only I am only praying that is in order prayer that decisions to be taken. which has been kept pending, my lord, the representation. I have nothing to say. No, this compassionate ground is not a cover with this, my lord, order, because the appointment has been given during the course of hearing of the earlier writ petitions, as well as the rule by the private respondent. Now I am seeking these decisions to be taken or to be considered in this representation. Well, let us know what decisions to be taken by the authority. I have stated in all these things. And all records I will also annexed to this representations, and it was served upon them. A petitioner is only the legal heirs and successor, and also having obtained the no objections of the others or of the family members. Now decisions to be taken, my lord. Only problem was that the rule was not heard out finally.
So Divakar Singh was the
grandfather of the MR dealer.
ration dealer.
Yes, ration dealer.
He expired in the year 1983.
83. Thereafter made an application. Because advertisement was.
See, we are now
In
No.
2025.
During this period, this matter is been at so many writ petitions as well as the rule was hard. But ultimately 2008, the last writ petitions was filed. In 2007 writ petition. That was
after another writ petition you have filed.
only 2 writ applications.
Two in
Only
2000.
If you are
2007 and 84.
Let's forget about everything. You are pressing the writ petition number 27579 of 2007.
7.
Okay.
Yes.
There was a direction.
Yes.
So where is the order? Rescind order is there.
No, that 2007 directions has already been considered.
Then contempt should have
And
been
during
filed.
this period, the mother of the petitioner died.
Whatever may be, where is you have never applied for the vacancy. Your mother has applied for the vacancy.
Yes, continuous. But during this, decisions ought to have given in 2007 writ petition as directed by this honorable court.
If the court, humble submission, if the court did not consider or if we were on a wrong pedestal, then a contempt should have
This
been
is not.
filed.
This is not a wrong pedestal
We
because
just say-
the petitioner has been applied for review to the authority, whereas the observation has been made out to this writ court that there is no any scope for any review, which has been granted or applied before the review upon the authority.
You understand the situation in
But
2000.
I know that. Only I am
No, no,
only
no.
praying, my lord.
Just take it clearly from me. In the year 2008, you got the interest to file a writ petition. You have got some order. Now, after receiving the order, you make it silent. Now you are appearing in 2025. Again, you want a direction.
No, mother had died in 2022.
So,
Now,
show
after
me
that, my
what
lord,
is the fate of the direction.
my lord,
What is the fate of the direction?
that's why, my lord, the son of the mother, my lord, has already
You
been
have
applied.
to say whether the
Exhausted
authority
application has been made out.
proceeded to the direction or not. What
No.
is your positive assertion?
No, ultimately, my lord, entire orders as well as the writ petitions has also been stated in this
No,
representation.
you have not taken the
But
point.
my lord,
What is the order of the authority in respect of order dated 8/8/2008?
my lord, yes.
What steps the authority have taken?
Such representations was considered by the Sub-Regional Controller Food and Supplies Khatra Bankura and by an order passed on 18 September 2001. That was rejected. That was rejected. In 2000, then 2008, that was observation of the court.
Yes, 2008.
Yes.
This court has directed, a coordinate bench has directed to the authority to dispose of the writ petition.
Dispose of the, yes.
The
With a decision.
So
That
what
was
is
not
the
done.
decision?
That was not done.
That was not done.
No.
That's what I'm saying. Then
Yes, my lord, kindly see. It was
also
also that is subsequently action to be taken by the petitioner. But it has been said it was also specified in the order that in the event
Here
it
you have
was found that the petitioner fulfilled all the criteria, the authorities were to take steps for delivery of commodities in favor of the petitioner. Such exercise was directed to be completed within a period of 4 weeks from the date of communication of the order. That 4 weeks period has not yet been complied with. There ought to be a filed a contempt application since connection with the order dated 8th August 2008. But even there is no any decisions has not yet been taken by the authority. Now, in the meantime, during this considerable period, the mother had died.
no, no.
In 2002.
Mother died 23.
2022 or 3?
23.
Yes,
23.
November 2023.
5th of November 23.
No, November 23.
Yes.
2000 since 2008 you were sitting tight. Silent.
I do not know after the demise of my mother, how many records are there or what records are
After, not
available.
after
of them.
demise, before demise of your mother, what happened?
That's why I am elaborated
That is not the
representation
chance
is made
read.
out.
That is
Elaborated
I cannot
representation.
allow to file the
This is
writ
a very
like that.
innocuous prayer that the
Not
representatives to be
prayer.
considered.
What
We-
your act since 2008?
But so far the representations are to be considered. Let them reject it. Let them reject it.
Show me a single paper since 2008.
And after that, nothing has been done.
Then
That was also
why you are making
that was
silence?
also that's why the representations to be considered.
No.
Only
Representation cannot be done.
Otherwise, that
After 20 years, you again appear before this court.
but on and from
and saying that
1983,
I have
but on and from 1983, another person, sorry, third person has been taking advantage and giving appointment that was not justified of this honorable court. Ultimately, she has been fight before this honorable court till 2008.
Look, you have to be clear and truthful before a court.
Because
What is your action since 2008 after passing a order of this court?
that's right, my lord.
Then
I admitted that no
since
steps were
2008,
taken.
2023, your
But
mother
she is
died.
awaiting. She is awaiting to get any reply
What outing?
or
What is
decision.
outing?
That's why, my lord, after died, my lord, demise, my lord, thereafter, my lord, I made an application.
2008, one order was passed in August.
Yes.
Thereafter, whether you have filed any representation with the authority, where is my decision? Where is the decision? Have you
That
filed
record,
any?
that record is not available.
Then
That record is
sorry,
not
then I
available.
cannot
That's why, my
entertain.
lord, I made an application.
No, that
If your
I
lordship, my
cannot
lord,
entertain.
dispose, directions upon the sub-general control of food and Resources, take a decision.
What decision? You have to
Decisions in regard
satisfy
to this,
me why you are silent.
in regard to this claiming.
This is a chance.
In
Read.
regard to this
You have
claim,
filed this read.
if your lordship,
If my chance may get.
if
No,
you,
no.
my
that
lord,
is
if
not
your
allowed.
lordship, my lord, will not entertain with this representation, then enter matter has been end. There is no any scope for any
It
reopening
is required to.
or reopening.
That is, you don't want to.
There is
reopen
also
the
my lord,
matter.
justifiable my lord, decisions
No, no.
to be taken.
The
I'm
petition-
not saying, but I admitted that on and from 2008 to 2023, she did not take any steps before the authority or decisions. If any decision has been taken or received, that record is not available. I could not procure of that. That's why, my lord, I made an application. One of the applicant, even after getting my lord, all records, even after my lord, no objection. Simply, you will also directions to consider these applications within certain period. Let them consider either rejected or allowed, whatever it may be.
There is
But we are depriving. My mother is also deprived. But I will also after died, I also deprived.
You
In regard to
deprive.
this,
Whether you have ever applied for the license? Whether you ever applied for the license?
no license has been granted. License has been granted in favor of the private respondent. She is working. She is carrying on business. Now, during this course of hearing of this rule, as well as the earlier two writ petition, even ultimately 2007, she was working. Even there is no any cancellation order. Now, in the meantime, the mother died, unfortunately.
Who is
And
running
we
the
are-
business?
One with the private respondent is the Aditya Singh Roy.
Who is Aditya Singh Roy?
That is my lord.
Your relative?
That is the son, Sudhanshu Sakhar Singh, son of Aditya Kumar Singh. Earlier, Aditya Kumar Singh, that is the father of the private respondent number 5. Now the Sudhanshu Singh Rai is
Two
my lord,
brothers
what?
के बीच में है basically.
Aditya Kumar,
Aditya Kumar Singh.
Aditya Kumar Singho.
My lord.
He is the
First
one of
title
the
page.
son of the Dibakar Singho.
No, no.
Sudhanshu Shekhar Singh.
Sudhanshu Shekhar Singh. There is a son of the private respondent. Aditya Kumar Singh.
Aditya Kumar Singh was
He is the son.
Given, yes.
in 94. Thereafter, upon his
My lord.
death, now
Basically, two
Sorry.
brothers are fighting.
You don't have any ground.
But only ground regarding the status of the case has already been made out of this representation.
What you made
That
out?
representations may be directed upon the concerned tribunal controller.
You cannot file
take
a
a decision.
representation after 20 years and say that my case was 20 years old. Please
After-
reconsider my case.
This representation has been made out after that. Prior to that, I cannot. It has the power of my mother, who was the read petitioner. That's why I am praying only for directions to consider the tribunal controller food and supplies at Khatra, Bankura. And your lordship's ballot, generally ballot, if your lordship's ballot, otherwise the entire matter will be, the matter cannot be reopened and also deprived. I am not saying that I am entitled.
Then when you are not entitled, why you are applying for?
But
File the
only representatives to be considered. Let them take a decision within a
How can
certain
it be?
period.
Very well, hard. Please take down.
Lordship, I am vehemently opposing this.
Affidavit of service.
It ought not to be considered, Your Lordship. There is another person is already there, no vacancy is there, and a person
Vacancy is also continuous.
person
There is no
the person before Your Lordship has not come with
No,
clean
questions
hands.
of vacancy is
No,
not
no, no,
clear.
trying to manipulate the courts. No.
No, I am not manipulated.
Let
I have already admitted
let
that
Lordship-
so long
Lordship
after
is
that,
not-
this representation has been made out. I am not full submissions or any manner
I have made my
mislead the court.
Let Lordship decide.
I also made out these petitions as well as the representations. I have already stated in the exhausted application. At the material point of time, concerned tribunal controller food and supplies was not within the tribunal. Only advertisement on that
The instant
application.
writ petition was filed seeking specific direction upon the authority concerned to consider the representation of the petitioner dated 22nd of August 2024. The representation is placed as annexure H of the instant writ petition. Full stop. I peruse the representation. It appears that one Dibakar Singh was ration dealer at Brahman Diha Gram Sabha within Raipur Block 2, District Bankura, who expired on 5th of December 1983. After demise of such MR dealer, a vacancy notification was published in the year. After demise of said MR dealer, a vacancy notification was published in the year 1984 for appointment of MR dealership. It is the case of the petitioner that in pursuance of such notification, 18 persons, including Parvati Singho, within bracket daughter-in-law of the deceased MR dealer, comma, bracket close, comma, mother of the present petitioner, considered to be the most eligible person for the vacancy. However, her candidature was not considered. So he approached before this court in writ petition number CR 15430W of 1984. Full stop.
A coordinate bench of the court has issued a direction on 22nd of April 1984. Of this court has issued a direction on 22nd of August 1984 to consider the representation of Parvati Singh Rai, which was not considered. Again, the said Parvati Singh Rai approached the court, this court, in a writ petition being number 27579 of 2007. Full stop. A coordinate bench did a order dated 8/8/2008 has directed the authority to consider the representation of Parvati Singh Rai in terms of a review authority, in terms of a power, under review authority. It is the case of the petitioner that the mother of the writ petitioner, namely Parvati Singh Rai, expired on November 2023. Thereafter, the petitioner has filed the representation with the authority to consider his case. Full stop. Ms. Sonal Sinha, learned counsel appearing on behalf of the state authority, has raised strong objection against any of the direction of this court. Having heard the learned counsel for the parties, also considering the matter, it appears to me that on the last occasion, by order dated 8th of August 2008, the coordinate bench of this court has directed the authority concerned to consider the representation of the petitioner in terms of power of review, as enunciated in the order itself. Since then, either Parvati Singh or the present petitioner never approached the authority. Now the petitioner has approached the authority to consider his case for appointment of the said dealership. Full stop. The petitioner has not demonstrated any document to show his bona fide that why he was silent since the year 2008 till today. Considering the same, it appears to me that the petitioner is not bona fide to approach this court. Under the above observation, I felt nothing. I considered nothing in merit to consider the representation of the present petitioner at this belated stage. Representation of the petitioner at this belated stage. Under the above observation, the petition is disposed of.
Grateful, Your Lordship.
Your lordship is disposed of it.
Yes.
Grateful one. Arguable. Disposed of.
Dismiss হওয়া উচিত ছিল।
Dismissed.
My lord, I am praying for short passover, my lord. My lord, Mr. Omoleshwar is appearing for the petitioner. Today is fixed for reply, my lord. My lord, he is engaged in another court. Short passover, my lord.
All are the parted matters. If I take up another matter, it will take today.
My lord, Mr. Roy will take 10 minutes, my lord. The notes of argument is also, my lord, supplementary notes of argument is also ready, my lord. Your lordship kindly short passover, my lord.
Okay, let's try. Pass it over. Next.
But I am for the petitioner in this matter, my lord.
Item number
Mr.
3 to
Chakraborty.
5, my lord, Mr. Pushpendu Chakraborty is appearing in this matter on behalf of the respondent, my lord. Due to some personal difficulty, he has to leave the
Mr.
court.
HON'BLE was there tomorrow.
He told me that he has some personal. He left the court.
Leave the court, my lord.
Yesterday he was there.
Yesterday
He was there.
Okay,
in the
if
morning
if your lordship kindly fix it and the next week, my lord, any
That
day.
is the three applicants.
My lord, yes.
Antora, Gargi and Nomita.
Yes.
Mr. Mitra has argued in this matter.
One matter, I am one
You have your matter.
Yes.
And Mr. Chakraborty has started the argument.
Yes. Almost.
So when?
My lord, any day next week, my lord.
Next week. Please take down. An accommodation is sought for on behalf of the respondent Indian Oil Corporation. Let the matter be adjourned to release the matter on
Monday, 2 p.m. your lordship fixed one matter,
Monday 2 p.m. I have fixed time. The Tuesday also I have fixed one matter.
So, Wednesday.
দেখুন তো কি আছে
দিনটাই পরে করে
হ্যাঁ
পরে
Wednesday
এভিডেভিটটা দিয়েছে টাইম
2 p.m. এ তো গ্রুপ হবে না
রেসপন্ডেন্ট নম্বর কত?
গ্রুপ 6 আছে না
হ্যাঁ।
দেওয়া ছিল কবে কথা দেখ না
গ্রুপ 2 দুটো ম্যাটার আছে আর তো কিছু নেই ওটাই করে দিন ওয়েডনেসডে 22nd
বুধবার বুধবার
22nd at 2 p.m.
My lord.
Yes.
Mr. Rai, letter, your lordship will take up this matter.
I'm sorry, my lord.
Very. Call the matter. Item number 2.
Or item 7, they have filed state just a minute, my lord. Item 7 is also fixed at 2 p.m. I shall pray for an adjournment because my lord, they have served the copy of the report subsequent to that expiry update. So we want to file the reply. Exception, 2 weeks time may be given. Sorry, reply, sorry.
My lord,
yeah.
may I file the affidavit?
Opposition.
Which matter?
Item 7, he's the state respondent.
Call item 7. Just wait, Mr. Rai.
Weeks time may be given to file reply because they have filed their opposition.
Affidavit in opposition file on behalf of the respondent 1 to 5 is taken on record. Petitioner seeks to submit a exception against the report.
Not exception, reply.
Reply.
2 weeks time may be given.
Reply against the report. Let the reply be filed within 2 weeks from date.
But interim order is maybe extended, my lord.
Interim order is there, 17th
Till
January.
17.
Let the matter appear in the list on
Time is available. Reply.
11th of February 2025. Full stop. Next para. Considering the fact and circumstances of this case that the matter was fixed for hearing of fixed for final hearing, comma, the interim order passed by this court on the earlier occasion is further extended till February 28, 2025
or until further order, whichever is earlier.
Matter to appear, my lord, 11th.
Matter to appear on 11th.
I'm grateful.
11th of February.
11th of February. Under the heading hearing.
And limited interim order is till 28th of February.
28th February. Or until further, whichever is earlier.
My lord.
If we dispose of the matter earlier, then it would be there.
Very well.
Grateful.
কিছু দেবেন
Well, AO files has been taken on record.
Call item number 2.
Applies, my lord. Petition. My lord, in reply, a statement.
Yes.
What I have understood from the replies of my learned friends, I just reply on the points. The first point, both of them have raised the question of maintainability of the writ petition. They said they submitted that it's a memorandum of understanding, is a private contract between the college authority as well as the petitioner that has been terminated. So it does not come within the realm of writ jurisdiction. This is my first, what I have understood, they have said first. This petition is not maintainable. But on this score, my submission is that, my lord, your lordship can come to page 89 and 91 of the writ petition. Well, in the earlier writ proceedings, we have challenged the order of termination of this MAU in the writ petition WP number 1027522. It was kind of the order first day at page 89 of the writ petition. But can you come to page 90, last two paragraphs? Mr. Dotto, learned advocate representing the state, submits that this is not maintainable because the dispute between the parties are in the realm of contract. Mr. Raghunath Chakut, learned advocate appearing with the college, submits that due to some malpractice adopted by the petitioner, the contract has been terminated. I am of the primary view the ground that has been taken for termination is not within the scope of memorandum of understanding. The college could not have terminated the agreement due to unavoidable circumstances. The order of termination as noted is yet to effect. In view of the primary findings, order was so my repetition was admitted despite they raised the question of maintaining repetition on the ground is a termination in the private realm. When the repetition was heard finally, then also this point has been issued. You also can come to page 93. The earlier final judgment order dated 17 August 2022, relevant portion, my lord. You also can come to page 95. Second paragraph at page 95. It has been submitted. Got it, man? At page 95, man. It has been submitted by Mr. Dotto, the learned advocate for the state, that since the dispute is arising out of a contract, the writ petition is not maintainable. Mr. Dotto further submits that dispute in private in nature, a state has no role to play in such dispute. I am of the view that there is no absolute bar to entertain a writ petition where the dispute is in the realm of the contract. In an appropriate case, a writ court may also entertain writ petition involving disputed question of fact. The point the judgment has been referred to, then also can come to My lord, next page.
This issue is not relevant to this point as you have challenged an act of the state authority in this matter.
No, what I'm trying to say.
In this matter, you have challenged the act of a state authority. Order of a state authority.
Yours is correct, but how the state, the power has been bestowed to the state government, that I'm coming. How this, my lord, it has been emanated from the first judgment and order that I'm showing you, lordship. So first, when we move the writ petition, I have challenged the termination of the memorandum of understanding. They raised the point rightly or wrongly that it's a private domain, so it do not, court has not accepted that point. Now, how the court has dealt with, my lord, can come to next paragraph, paragraph 96, page 96. I also do not accept the content Mr. Datta that has no role to play in the facts of case. The state has promulgated the West Bengal, this act has been referred to. Next, my lord, page 97. The state, in terms of section 18 of the said act, has the authority to give directions to any college or any university in any matter not inconsistent with the provision of this act. The college or university shall be duty bound to comply. Emphasize subtype. In the present case, having regard to the dispute question fact involved in the case, I'm inclined to give a direction of the state to issue appropriate direction in terms of section 18 of the West Bengal University and College Act 2017. In that view of the matter, I dispose of the writ petition giving a direction of the Principal Secretary Department of Higher Education to depute a competent officer to look into the grievance, of the petitioner as made out in the writ petition. So my humble submission is that, my lord, what your lordship said, before that I say, I have challenged the memorandum under termination of the memorandum understanding. Their fundamental point that it does not lie. That point has not been accepted by the honorable judge. And first and final order that yes, you have a power under section 18. State has the power that my learned friend said state has no role. My learned friend has failed to see this, that the honorable High Court, the coordinate bench has already decided, hell, the state has some role under section 18. And in exercise of the section 18, the honorable High Court directed them, any officer of the government, to decide the grievances. Like what is the grievances of the petitioner, my lord? I candidly say regarding termination, prematurely termination. So, my lord, this judgment has reached to the finality. They have not challenged this. Rather, on the basis of this, they have acted upon. College has not challenged this judgment, and the state has also not challenged. Rather, this judgment has been acted upon because all of us participated before the Director of Public Instruction. Now, my lord, second point is yesterday I said I am trying to submit, my lord, that a power has been given to the state authority in terms of the Act, section
The
eight.
act.
Yes, we act. A public
Section 18 of the act.
West Bengal University. I'm giving one. So, my lord, section, the honorable, in the previous occasion, the honorable judge held that in this type of case, state government can interfere in exercise of section 18, and that findings has not been challenged anywhere, so it has reached to a finality. Secondly, it has been acted upon because all of us participated. Now, my lord, can see the Director of Public Instruction. I'm not challenging the other action of the state. Here, Director of Public Instruction is a state authority or rather instrument of the state. He has passed an order. He has been bestowed with the power given by the court to decide the issue. My lord, I have challenged now my lord, subject to lawsuit. So the order of termination, the termination order that has been merged with the present order of the my lord, Director of Public Instruction. Because I have challenged the termination order. Court has asked the Director of Public Instruction or any officer to decide the grievances, not the issue, the grievances. When the grievances has been decided in my favor or not in my favor, so the issue
that whether question of termination of the MOU is correct or not, that has been merged with the with the culminated with the order of the Director of Public Instruction. So the order of the Director of Public Instruction can be subject to challenge, subject to judicial review in a jurisdiction that cannot be disputed by them. They have said regarding the termination of the MU.
Now, how far you can challenge the DPI before a read court?
Yes.
Whether in the merit or the procedure adopted by the DPI.
My lord, you also
have appeared, you filed the written notes of argument.
I answer.
Everything.
You also the decision cannot be challenged unless there is a four corners,
Yes.
4 points: illegality, perversity, or irrationality, and
Or
beyond the law.
fundamental right or the
Beyond the law. But this is federal law.
of natural justice.
So I have the right to challenge the decision-making process.
Yes.
That I have a right. Now yours is there is no decision-making process that cannot be challenged because, my lord, that that is because, my lord, there is a decision has been taken at your presence. I'll give two judgments. I'll show my judgment.
My lord, a factual aspect should not be, my lord, repeated.
I know factual aspect.
Only legal aspect. And the judgment which my learned friend is going to be relied upon, we have no opportunity to counter that judgment. That being the situation.
You have raised a new question. These are the points that there. You have not said this.
Not new question. They have not raised. I am raising you question.
Yes, then I have to answer.
Why you challenge? How far you can challenge the DPI when you appear before the DPI?
Just
file written notes of argument.
Yes, ma'am. I have brought one judgment. Please, just a minute. While I just.
How far the decision is so perverse, you have approached the writ court.
Yes, I will answer it, and they have not dealt with this matter. I'm grateful to your lordship. I'm coming to this. And look, এখানে থাকলে যে এই judgment আমাদের সব ক্লাস বাড়ছে এখানে বলেছে 220 কখন করা যায়? In anticipation, I brought one judgment. Yes, sir. I just. So, my lord, on the question of maintainability, my point is that read lies because of this is my point.
Yes.
But they have stopped. What I'm sorry, I said that stopped from raising the question of mandatory repetition because the issue has already decided in the earlier repetition, which has not been challenged.
Yes. Now your second ground.
Now is what?
Reply.
And reply. Abandonment of the relief. My learned friend has raised a question. I can't ask for relief, which once I have asked for, and without leave I cannot ask for. Now, you also kindly come to page 50 of the read petition. আগে read petition পাচ্ছি না কেন? আগে read petition আমার কাছে আছে? আগে read petition.
Page 50 is the prayer.
Prayer. You also can see my learned friend has said that I can't ask for this prayer. Thank you. My lord, thank you. That B, read on the nature of B, my lord, mandamus, commanding the respondent, each of them, their servants, a person working under the immediately settle, cancel, withdraw the order of termination. I have challenged again. My lord, I say one thing, my lord, that that has been quoted, cut and paste from the earlier read petition B.
Yes.
But my answer is that this prayer is not required. It is an innocuous prayer. Because when I challenge the order of termination earlier read petition, court has, after considering, asked the Director of Public Instruction to decide the issue. And Director of Public Instruction has decided the issue. Now, whether it is bad or not, I am coming. So then, this prayer, or question of termination is bad or not, that is merged with the final order. So this prayer is an innocuous prayer. Even if this prayer, because for A is my fundamental prayer. So this read petition should not be vitiated because of this prayer B. You also this prayer may be.
All the prayers are similar to the earlier.
No, only A is the B, C, D, or these are
A. Except A, all the prayers.
These are
pasted it.
But these are all innocuous prayers. You also kindly allow me to, my lord, you also will not take into consideration all the prayers. Mainly B, mainly he said B. So my lord, you also can see what my learned friend says. I have another point of argument that I should take a leave or withdraw. But there's no scope of taking the leave because all the grievances are decided. The landed court says, Honorable Single Judge said, when I moved the earlier requisition, directing that officer to look into the grievances of the petition. So this is a wide range. So what I have raised the grievance in the earlier petition.
And what grievances you have raised before the DPI?
My lord, I have raised the question, the 2 point.
You have raised the grievances, your grievances before the DPI, that there are certain huge amount of money is
not that is the issue.
They are not.
No, that is not the issue.
This is your written notes of argument.
No, I have said in additional, but that is not the issue. I'm coming, my lord.
No, page 231.
Yes, I said, but this is not my issue. I'm coming, my lord. Yes.
In written submission before the
yes
DPI, you have focused only about your money, revenue.
No, my lord. This is
You
not
read
right.
the paragraph, second paragraph, page 233-21.
233?
Petition.
233?
321.
321. Just a minute.
That is the impugned order.
But this is 321 is not my, it's not my view. Not my, I'm coming, my lord. I answer it, my lord. I get my lord, in I just answer it. I answer one by one. Others, but so with regard to abandon of the relief, my lord, in my London friend, and thank you to my London friend, the earlier repetition, I have challenged the termination letter. I have challenged that I have can you see in the earlier repetition your lordship's file, my lord. I have in the earlier repetition I have challenged the termination order. I have asked for asked for a issuance of mandamus to continue my memorandum of understanding, and I have nothing, no more prayer. Because the money I have no prayer. Consequently, in the earlier repetition, my grievances are two. One is grievances is that my termination. Other, my lord, my positive point that they should continue my memorandum of understanding. This is my only two prayers. And see, the earlier repetition.
Yes, I have seen.
At page 15 and 16. Thank you. But then, my lord, in the present petition, what I have challenged? That's 50, my lord, can come. 50, I have challenged the order of the DPI. B is, my lord, regarding same prayer for cancellation. My lord, can you see third prayer C also to continue me? And my lord, I have no prayer really with regard to the monetary claim. There's no issue is there. Now, my lord, I will place second thing when the Honorable Single Judge was directors to go to venture or give us with the director of administration with grievances. Can you see my written notes of argument that I have not taken this point? You also kindly come to page 77. Sorry, my lord. It is from page 83. No. Sorry, it just a minute, madam. Madam, kindly come to, sorry, page 99. From 99 to 112, and other documents are there. My written submission, 99 to 112. That the written notes of submission I placed before the DPI. I have not seen anywhere regarding my claim of monetary claim. Although, my lord, I'm grateful to DPI, he has decided it, not rightly. So, when I move the because my also can appreciate, in the earlier my grievance is cancellation termination, and I shot for continuation. And court has not said in this specific court said to look into the all the grievance raised, not grievances, the grievance raised by the petitioner. So my grievance is two. First, one is termination is bad, and I should be allowed to continue.
No, page 112 is not the complete.
Yes. This is 12 my complete, my.
It is not complete copy.
No, my lord.
Written note.
But transfer brief also. No.
What is the rest portions?
57 पर कोথায় আছে রে? আর নেই তো। এটা 57 দিয়েছে। এখানে এরপরে মাই লর্ড এই যে আমিও তাই বললাম 112 পর কোনো পৃষ্ঠা আছে?
After 112, there are some copy of admit card of a student.
Oh, these are annexures.
But what is the last portions of the written notes of argument?
Prayer portion, my lord.
I do not know whether prayer portion is there or other
Or other part. My lord, এটুকু তো দিয়েছে। Well, my instruction is that we have not raised my lord subject to loss of correction. I just say transfer, I'll get it. My lord, my lord, so my grievances is that it has been, my lord, propped up from my earlier petition that regarding cancellation, and that is the honorable single judge was pleased to direct them to look into that grievances. So the money relief is apart from my other reliefs. Now, I'm going back to my lord, the abandonment of relief. My learned friend has pointed out that this PR I should not make. He has rightly said. But this PR, because in addition, my submission is that these PRs are not required. It's an innocuous PR because when I challenge the final order, which is passed by the DPI, then other PRs, subsequent PRs are ancillary. These are innocuous. And secondly, my lord, my learned friend said I have to take the permit leave. There's no, because the judgment which has been referred to by my learned friend, that there are many prayers. If one point is decided, I should take a leave under order 20 rule 1. Regarding this situation is not applicable here. It's not here. The only one prayer that has been dealt with.
Yes.
So this judgment, the ratio of this judgment in the present fact is not applicable because here in the read petition there is one point that has been dealt with by the honorable single in the earlier judgment and ask them to look into the matter. So my reliefs, subsequent shortfall, even those are not there, my read petition will not go. Because I have challenged the order of the DPI. This is my answer.
Yes.
Now, my lord, they have raised a question, and DPI also said in the DPI also said, my lord, you also kindly come to the order of the DPI at page relevant pages at my lord T22.
Yes.
Second paragraph, last 2-3 sentence.
Yes.
The affiliation was for 3 years.
Yes.
And after the expiry of the affiliation period, the question of continuation of BBA from this college through its collaborating partners alike does not arise at all. So the DPI has arrived the findings. Since there is no affiliation more, so there is no question of continuation of why this findings is bad. And my learned friends, not my state learned friend, has also strongly relied upon this point, says that there is no affiliation. So the entire read become infractuous. No, but this is not correct. I will place with why. Well, if you also kindly come to supplementary. Well, you guys can supplementary affidavit filed by me.
Supplementary affidavit filed by you?
Yes, read petition.
Filed by the read petition. এখানে আছে
At page 14.
Supplementary affidavit on behalf of the petitioner.
Yes. Got it, man.
Yes.
Your Honor, can you come to page 14?
Yes.
Page 14, can you see? This is an order of affiliation, grant of affiliation by the university at page 14. But it's a BBA course for duration is a 3 years. You also can take into mind it's a BBA, it's admitted fact. This is a BBA course for purely 3 years. The application has been given for 3 years for the 3 sessions, to the 1920, to the 2021, to the 2022 sessions. So university has given this affiliation. They are correctly pointed out for 3 years for the 3 sessions. And session has started from 19. And the duration of this course is for 3 years.
Yes.
Now you'll also kindly come to, I'll show one thing from my memorandum of understanding at page 58. Page 58. But page 58, when the first page, this memorandum of understanding was executed on 6 February 2019.
Yes.
So first memorandum of understanding was executed between the parties. And can you see the clause 15 of this agreement at page 62? The governing body of the first party shall review the progress of the institute of second party and renew the agreement on the basis of satisfactory performance. But the tenure of the memorandum MOU is not given anywhere. But there is a clause of renewal subject to satisfactory performance. Now, you also can appreciate they first entered the memorandum of understanding on 6 February 2019. Then they applied before the university, but this is a minor procedure. Before the university, university has granted on 24th May 2019. What I'm trying to say, at first, our memorandum of understanding, then the university affiliation. If in the present case, if there is no termination, if there is a renewal, they can't answer, they have not answered the state respondent. Suppose memorandum of understanding has been renewed year 2 years. There is no, can you see the tenure of the memorandum has not been given anywhere. Only clause is that it can be renewed. So my submission is that college has entered an agreement with us first. Then college approached the university and state council. They have given the affiliation for 3 years. I put a question to my learned friend. If suppose this memorandum of understanding, because the pure of the memorandum is not given anywhere, it will expire. There's a clause of renewal subject to satisfactory performance. So it may be the part in perpetuity also. For a long time, one condition, I have to perform my action satisfactorily. So suppose in the situation that memorandum of understanding is there, it is renewed and process is going on. They have not answered whether university will not give the affiliation. This question, so both the DPI as well as my advocate, here my learned friend has said to bypass the point that no, it becomes infractious. Because there is no affiliation. I have challenged the action which is not after appellation, after expiry the appellation, but I challenge the action which is within during the period of the appellation. In other words, I say that the honorable single judge was pleased to direct them to look into the grievances, which grievances are not after expiry the appellation, which is during the period of the appellation. In addition to, I said, appellation is in a routine manner. The university has not said, no, I will not, after 3 years, I will not extend the appellation. Here, the college is the authority, college is a function of college, they will apply and it will get. So, on the question of that application is no more, so your entire matter become infracture. This is not correct. This aspect is not correct. Secondly,
your submission is that if the order is passed that the termination is invalid, so the memorandum of understanding will revive and the college authority shall apply for the affiliation.
It's a legal obligation on their part, contractual obligation. And university has not said, no, I will not give further. University, I have given for the 3 years. You also can see, now I'll show one other thing. You also can see.
Only one question which that is not relevant to this writ petition, I think. This relevancy of the writ petition is in respect of the order of the DPI.
Yes.
Okay. So you are arguing on the basis of the agreement between you and the college authority. How you sign the agreement? There is no clause to challenge the order of the authority, cancellation and everything on the behest of the college authority. If college authority found to be relevant, that he may anytime.
Now you also raise another point. Whether college is having I'm answering. I'm thankful. You also said that college has the ample power to.
Yes, college has ample power.
Ample power to.
Anytime.
Yes, I answer.
This
is my basic point. I'll answer. So you're under the memorandum of understanding, college has the power under clause 17.
Yes, clause 17, clause thereafter.
No, the clause 17 and 15. 17 and 15 is my operative part. You see.
No. Clause 22 clause governing body of the first party will review the progress of the course.
No.
And renew the agreement. What if they are not satisfied about?
Yes. You're also absolutely correct. I'm coming to this one. I'm thankful, Milo. I got answer to it. Milo, can you see? Yes.
Do you have any authority to challenge their review process? You have no.
They have not reviewed. This is the main point. Well, I'm coming. I just, my lord, this is my submission. Can you see the memorandum understanding? I just, memorandum understanding 15 at page 62. The first clause of the memorandum understanding.
No, what DPI has said, you just follow the order.
DPI said I answer. I will reply. Entirely influenced by extraneous things. I'll place it. I answer this.
Yes.
DPI findings, why DPI findings, they have not dealt with this. I'll place it, again I'll place it. You also kindly come to page 62 for a moment.
Yes.
My lord, now, my lord, yours is in the absolute patent point, is a fundamental point. Can you come to page 62 of the memorandum understanding for a moment? Clause 15 deals with, my lord, renewal clause. Can you see that clause 15 deals with renewal clause? Only renewal clause subject to a satisfactory performance. My lord, I repeat, my lord, There's no tenure of the MO is given, stipulation is not given. Now kindly come to clause 17. 17 here they have applied clause 17. That in view of anomalies, they have applied this, my lord. What are the anomalies? Unfair means in candidature or examination. They have given the degree. They have given the qualification of the what is the qualification of the anomalies? What is the degree? Like unfair means in candidature or examination. In any of the existing procedure, the governing body of the first party shall be at liberty to terminate here the time. There's no here. This is here no. You lost what you lost is in mind. Here they said no, we not renew more further. Then I have nothing to say. If they say no, your progress is bad, I will not review it. They have invoked clause 17. They said we got the anomalies, and so we have terminated it. The anomalies is defined, or example was given like an unfair means of candidature of examination,
etc.
etc. So etc. is that will be like a etc. It cannot be the others. It can be should be in a nature of unfair means in candidature. Etc. does not include that non-supply the books. Etc. does not include other teachers. So that should be in the standard of unfair means in candidature. But my lord, this is the they themselves illustrated what is the anomaly. The decree has been given. So etc. My lord, not all. That should be in the same nature. So they have invoked 17. If you also correct, my lord, what DPI said, DPI now has taken the and show it. They have not argued this. They have taken the legs of the clause 15, not 17. Why they have invoked 17? It is rightly invoked or not, this is the issue. Now, my lord, 17, but it is admitted fact, I show it, my lord. 17. Then you will also kindly come to clause 22. The governing body of the first party will review the progress of the course and renew the agreement on the basis of satisfactory performance through a continuous year renewal process. So there are two clauses for renewal, 15 and 22, and 17 is a clause for termination, suspend, and any point of time. But there must have some anomalies. And the degree of the anomalies has been exampled. Well, your loss is my queries. Well, if they say no, I will not renew further. After seeing your progress, I will not renew. Then I have no case.
So, Mr. Rai, in the writ petition, how can I go to the merit of this?
My lord, that court that my lord.
Such type of
my lord, is the first time.
There are some issues whether the anomalies they have considered to be taken or the anomalies.
My lord, I'll show it, my lord. I'll show it when the writ court can extend it.
As per the
my lord, writ court, when the whether
writ court go to
but
the
this is
evidence of that matter.
But this no. There's no question of evidence. I'm kind, my lord. The writ court, at the first stage, if the writ is dismissed on the question of display question of fact, then I have nothing to say. The earlier judgment, which has reached to the finality, has given the ample scope. And scope has been given to the concerned authority. My lord, now they can raise this question that the disputed question of fact, it cannot be decided by the writ court, it should be decided in the civil court. On the contrary, I have to show before lordship that when the Director of Public Instruction has relied upon, he has relied upon the documents extraneously. That point I have argued already, they have not dealt with. Or the findings are perverse or not. That I'll show. My lord, here the issue, and now fundamental issue is whether the college could have terminated this memorandum of understanding in exercise of clause 17 on the alleged ground of anomalies. This is the point. And the grievance means the Director of Public Instruction ought to have taken into consideration what are the anomalies and rightly has been invoked, or clause 17 has been rightly invoked or not. That is the point. Now, my lord, Now so with regard to, I'm going back again, then I'll come. Extension of the affiliation that has been extended, so losses right, efficacy is not correct. Because if it is a question of renewal, suppose it has not been renewed, because university has not given the affiliation, then I have no case. Question of grant of affiliation does not arise here. Here the action which has been taken by the college authority during the appellations was in subsistence. So secondly, my lord, it is not the case that the university would not give the affiliation. Suppose this is not the case made out by them. But only DPI said there is no can you see
Okay, you have read out the DPI order.
Yes, can come to this. T23.
You have read out the DPI's order.
This is T23 last second paragraph, third 3 lines.
No, that is that
No, on this point, I'm coming on the point of affiliation. What the DPI says, the affiliation was for the 3 years, and after the expiry of the affiliation period, the question of continuance of the BBA course from the college of its collaborating partner, applicant does not arise at all. These are only findings. It's a cryptic in nature. Then DPI should, because university is a party. The university can ask the university. You will extend it further. DPI has been asked to look into the grievances, whether the termination was bad or not, by invoking clause 17. Instead of DPI said, like my learned friend argument, they have evasively said, no, this point cannot be decided furthermore because
you start the paragraph.
Yes, I did it.
Start the paragraph.
On
scrutiny.
This I'll decide. I think on scrutiny of the materials made available by the parties, the undersigned is of the view that when some anomalies in the matter of quality education as per standard provided by the WBC UGC are pointed out, the reports of 2 committees. Now I'll come the report of committees. What committee's report says? I'll show you, your lordship. This is absolutely I should not say malafide, non-application of mine. There's one report.
Sir, do you have any authority to challenge the report of the committee?
I'm not challenging the report.
Then?
Report is in my favor. You can show the report is in my favor. I'll place it. My lord, just kindly, one by one, I just come. I'll answer all the questions, man. So, my lord, my third point is that on the question of non-external affiliation, my lord, read this.
You have argued. You have argued.
Now,
I understand your argument.
The second point, can see why. Can see this another point. And I'll show another 2 things that will very. My lord, can you see?
Yes.
Now, my lord, you also can come to page 14 for a moment of this essay, this supplementary affidavit. I'll show another thing. Page 14.
Page 14
of this supplementary affidavit.
Yes.
But the session starts to the 1920. Yes, madam. A student got admission. I got it, madam.
Yes.
A student got admission to the 1920. When he would pass out, he would pass out in the session to the 21-22.
Yes.
For 3 years. If a student took admission to the 20-21 sessions, when he will pass out to the 22-23. If a student took admission in 2021-22, when he will pass out 23-24.
Yes.
So, my lord, they said there's no affiliation. So matter ends. But here, what's the effect? What's the subsequent effect of that affiliation? This is 3 years course. We are giving study. Can you see they have not seen the interest of the students. A student took admission in 2020-21 and he will pass out on 23-24. Before that, this subject, this course has been stopped, closed. Now, I'll show one thing, another thing. They have not answered to this. In the supplementary affidavit, they have not answered. If you also kindly come to page 3 of the supplementary affidavit for a moment.
No, by supplementary, what you want to prove?
I'll show.
By supplementary, why you file the supplementary affidavit?
That is, my lord.
What fact you want to prove?
Can you see the E, my lord? E.
Yes.
Surprisingly, the memorandum of understanding has been terminated. But in the official website of Sarojini Naidu College, for it is beyond display, is being displayed that BBA 3-year specialization course in tourism, aviation, and hospitality is being run by Sarojini Naidu College of Women in collaboration with the petitioner 1. The session 2020 is still going on the said college. A copy of the advertisement regarding BBA course in tourism is in the official website is annexed here to marked as answer 26. Also, can you come to page 20? This annexure, my lord. This is at page 19. And this is from their official. They have not disputed it.
Yes, my lord, disputed by filing our, my lord, affidavit reply.
No, you have not said. I mean, I read it.
7.
I read it, but your authenticity has not been challenged. Man, can you see?
Mistake does not confer any right.
Mistake. The department BBA with Avalon section was established in 2019 with the object of enriching students towards dynamic career, a self-finance course whose students are provided with 3 years degree course structure. My lord, can see the admission to 22-24. They have said. Next page, can you see? They have said students stand in subject tourism. My lord, they have given the year 2022-23. So affiliation is not the issue. I got it at page 20.
Yes.
So my on the score of affiliation, non-excessive affiliation, I say that cannot be taken into consideration to decide this writ petition, my lord. They themselves continued it. They said in collaboration with us. They said in the reply, this is a mistake. I've read the reply. They have not disputed the authenticity of this document. They have said it took place because of some, my lord, mistake. Is a mistake in malice or mistake in facts that I am not going to decide. So now, my lord, you also kindly come to
show me how the order of the DPI is purpose.
Yes, I'm coming. One by one, I'm coming. Now you also can see. Yes, now I am come. My lord, before that, your lordship, can you see the order first? Then I'll come to the DPI orders. Why DPI orders? Can you come to page 77? এটাতে আগের অপোজিশনটা আগে করবে
Yes.
My lord, you also kindly come to page 77 for a moment of the writ petition. This is an improved order of the earlier petition. You got it, man? No, sorry, man. But they say they all on a sudden terminated. Can you see with effect from 1st July 2022, they said for unavoidable circumstances. Now, when you challenge this order, they filed their affidavit in opposition in the earlier writ petition. Now, if you also kindly take the, I am given a copy, kindly see there, kindly, you also kindly take note of it. This is on the record also. First, at page 23 of their opposition.
Want to demonstrate?
In the minutes of the, now, when the order was passed, they said, they have not said anything. They said, for the unavoidable circumstances, you are terminated. No reason, nothing.
These are all factual aspects.
But my lord says, why this order is bad, I show it. My lord, so in the evidence opposition, they first disclose the minutes of the governing body. In the minutes of the governing body, they say they have taken the 4 points. That point has not been dealt with by none of my brothers, friends. They have said, my lord, that because of non-supply of books to the students, denial of mandatory internship training, and non-engagement of qualified teachers, these are the anomalies. On the basis of they have asked for to terminate the. These are 3 points they have taken to. This is a quality of education. They have said books are not given, although in the written notes are going to have given all the papers. Denial of mandatory internship training and non-engagement of qualified teachers. And my lord, if you also kindly see, there they have said another thing. If you also kindly see that page 23 of their minutes of the earlier evidence opposition.
Yes, read out.
Your lordship's my lord?
No.
At page 23 and R2 of
What you want to demonstrate now?
From here it is that they say they relied upon 2 reports. One report, principal placed before the governing body, the report submitted by the annual monitoring supervision review committee. One. Second, they said they are governing body directs the principal to inform the department, higher education, and to regarding discontinuation of the course. So department, the university has not stopped affiliation. They said they asked the principal to intimate to stop it. They said this order was passed because of 2 reports. One report is, my lord, submitted by the annual monitoring supervision review committee. Another report has been given by one Professor Pranam Dhar.
Yes.
Now you also can see the Pranam Dhar's report.
No, I should not go to the report.
No.
The report was placed before the DPI.
What report says? Report says otherwise. But DPI has purposely taken into consideration. Report, you can see 2 points are there. There is 2 reports. One of the report says not to terminate, to give us liberty to rectify.
Yes.
That I placed before last.
I have also read the report.
So
this report was placed before the DPI.
No, one is not. Can you see?
That I am not in a habit of interrupting, but I should interrupt now. Why? Well, friend is placing the report, saying that what are the details of the report he knows. Well, kindly come page 27 of this particular present. Kindly see for once, I'll show only one. The Director of Public Instruction, Government of West Bengal, passed the order dated September 23, 2022 on the basis of 2 reports. One submitted by the annual monitoring supervision.
Yes. Why? What's wrong?
But neither the Director of Public Instruction, Government of West Bengal, nor the respondent college supplies the copy.
Yes, rightly said. Rightly said. No, that my language has not read it. And I say that I'm fighting, I have not read it. What I'm saying. No, what I'm saying. No. This is very bad. What? No. Sorry. Well, I answer it. My answer it.
I understand.
No, I answer it. I answer it. What I said, my lord. Can you see what I said? Please.
Character B only. I won't test anything more. Character B.
My lord.
They have not supplied the report. They said in the report.
No,
Yet nothing has been supplied these two reports. And when anybody is now placing on the reports and what has been said.
Well, he has intermingled the two reports. This is the main problem. That's not my can you,
He didn't go, but he knows it is
my lord, my lord,
okay,
that-
okay,
my
okay,
lord,
just
that-
wait.
my lord, he has not followed me. This is the main problem. No, your lordship, can you see? I have to answer. Now he made a aspersion against me. I will answer him. My lord, your lordship can see. When the order was passed, they said for the unavoidable circumstances, it was terminated. My landlady was not in the earlier retribution. Also, I am not. My landlady is there. They filed an evident opposition by the college. They have disclosed the minutes of the governing meetings, and there they said the two reports. On the basis of report, one report is given by the annual monitoring committee, another is given Dr. Ponam Dhar.
Yes.
Dr. Ponam Dhar's report was annexed. But this is at page 54 of their opposition. In the Ponam Dhar reports, Ponam Dhar has taken all the points. But ultimately he said that we should get a chance to rectify us. This is the time. And regarding that annual report of the annual monetary supervision review committee, I said I did not get this copy. I don't know what is the content report. My landlord has intermingled both. I said there are two reports. One report of the annual, this is my lord, monitoring review committee that has not been annexed, that has not been supplied to us, that has been not given to by DPI to us.
Whether you have placed before the DPI that the report was not placed?
No.
You have not
No.
placed. You have not
My point is that, my lord.
There is no chance
My
of
lord,
prejudice. That is why, my lord,
that has not. I said you have not disclosed this. But yours is correct. I should ask from the DPI. My lord, the report still now this report is not, my lord, bring to the light. They have brought this report. Can you see? They are in the opposition. They have disclosed this report. Well, you also kindly take judicial note of it.
They placed the report before the DPI.
That should then annex in the opposition also.
They have placed the
But you
report.
also kindly
Ask for the report.
you also taken another point, technical point. The report has been placed before them. I don't know whether placed or not. I was not there. So, my lord, suppose that was placed. I have not asked for the report first. My lord, when the report was placed before DPI, my landlord is appearing on the DPI, then he has to, every opposition come disclose this report. Why he has disclosed it? Can see. Ask him to bring the report. So my 2 points. I'm not going to this. My point, there are 2 reports. One report I have not, that has not been brought into the light. And that has been annexed in the present proceedings.
Now, what DPI said about those reports?
Yes, that I'm coming, man. That I'm coming.
Last
Yes, I'm coming, man. What is the perversity of the DPS findings? I'm coming. I'm coming, my lord.
You see the page 3.
Yes, I'm coming. I'm grateful to. I point out it. Now, I'm coming on this point. I'm coming. That when I argued in the segment way. First, my lord, DPI. Just sorry, my lord. Sorry. What I'm saying, I'm trying to say that they have terminated. It appears from the minutes of the managing committee, which was disclosed by the affidavit, that they relied on 2 reports. I again said in the evidence opposition, they have not annexed the report of that supervision committee, but review committee, but they have annexed the report of the Ponam Dhar, the 2 reports. In the Ponam Dhar reports, Ponam Dhar has given the advice that we should be given a chance to rectify ourselves. And there's another report that has not been brought into the, my lord, light still now by them. But you will also ask me why you have not asked for this report. This is my laches. I can't deny it. Now, my lord, Ponam Dhar report, if I read, there is a scope. Then I'll come. So can you see now? Can you see the order at page? Now I'm coming one by why this order is back. Can you see 22?
Yes.
On scrutiny of the matters made available by the parties, the understanding is the view that when some anomalies in the matter of quality irrigation as per standard prescribed by the UGC, or pointed out the reports of the reports of two committees. The college authority was not supposed to consult the collaborating partner. See, this is an agreement between us. They will allow us to reappraisal or progress or.
Is there any agreement?
Which one?
Is there any point of agreement that before consult?
Mali,
Is
you're,
there any
Mali,
term
you're,
of consultation?
Mali, you can appreciate. Can you appreciate? Principal, I'll show you my locality. Procedural, my lord, there's an agreement.
Yes, agreement we have to bound by
I answer. Agreement. They have a right to terminate on the ground of anomalies that has been explained by invoking clause 17.
Is there any clause that they shall call for explanation?
My lord, I'm sorry to say, I know, my lord, this is by civil consequence. My right will be taken away. They will not give the report.
No, the DPI has
The
opined
DPI says that when they have taken.
not supposed to
This is
consult
correct.
the collaborating partner.
This is
There is
correct.
no such averment in the agreement regarding your collaboration
No,
with the college authority regarding your termination or anything.
No, the collaboration is there.
Show me the provisions.
Can you see?
Is there any provisions in
Which
the
one?
agreement
Yes.
that the college authorities shall ask for explanation or anything?
My lord, your kindly appreciate. Yes, yes. I answer it, my lord.
If there is such agreement or terms,
No, my lord.
the order is forward.
My lord, your lordship kindly see. Then my lord, sorry. Your lordship kindly come to the agreement for a moment.
Yes,
This may want to understanding. Kindly see the object of this agreement. Then your lordship kindly come to clause 13. 13. Before the clause at page 61, first 12. The first party shall have the right to constitute monitoring team to review the progress at the institutional level of the second party. Then, my lord, 13. The second party would submit to principal of the. I'm coming, my lord, an appraisal report indicating the performance of the students of each year. Third, such appraisal report should contain the following: the duration of class, the subject tutored, and all things, the number of candidates. 15. The governing body of the first party shall review, not only review the progress of the institution of the second party and renew the agreement on the basis of the satisfactory performance through a continuous year renewal process. Then 17. In view of any anomalies, unfair means in candidature, in any of the proceeding, the governing body of the first party shall be at liberty to terminate, revoke the memorandum of understanding by 1 month prior notice to the second party. What is the notice? This is why I'm coming to Malad. What is the notice? The principal notice is violated, my lord.
No, I wanted to know whether there is any scope for your consultation with the
prior notice. My lord, I should not say much more that my lord, you appreciate. When the notice.
You are saying that the
prior notice should be given
before revoking or terminating the license.
My lord, DPI has done consciously. Why I'm saying? ভাই তোরে বলিস না সিনিয়র অন পড়ে আছিস ভদ্রস্থ হয় একটু
Yes,
this is very bad.
No,
I think my lord, can you see what I'm saying, what I'm trying to submit? The clause 17, they have a right to invoke on the two conditions, my lord. If they are the anomalies, what are the anomalies that they have said? And secondly, they have to give a 1 month's notice. In the present case, you also appreciate that first they said unable circumstances, then the evidence they said these are minutes of the governing body they have disclosed, and London is disclosed, and there they have said for 3 reasons they have not given, they have terminated. Thirdly, they have said, my lord, there's 2 reports. Now I am placed on the face of it, one report says, no, don't terminate, give them chance. Another report has not come to the light, although I should ask for. Now DPI says there are anomalies. DPI has failed the application. Can you see what is the perversity? What is the perversity of finding the DPI? DPI should see first what clause 17 says. What are the anomalies? If there's an anomalies, those anomalies are disclosed in both the reports or not. If those anomalies are coming within the purview of the clause 17 or not.
You see the page 321.
Yes.
321, first page, last 5 lines.
Yes.
When both the reports mention committee and the chairperson of the.
Yes, my lord. I please. When both the reports of monitoring committee and chairperson point out some grave anomalies. What are the anomalies? Well, this is my point. What are the anomalies? Grave anomalies like non-supply books. Is there anomalies? But this is my point. They have not dealt with this point. My point is that this in my notes, I have written this in such a way. The Director of Public Instruction erred in failing to appreciate that clause 17 restricted the scope of termination only on the ground of anomalies, unfair means in candidature or examination, non-supply books, denial of mandatory internship training, non-engagement of qualified faculty cannot be treated as anomalies in the context of clause 17 of AMM. But this is my point. They have not dealt with this.
Okay.
This is my first point. My lord, DPI has said that there are some anomalies on the basis of report. The anomalies are, my lord, enumerated. My submission clause 17 does not hit those anomalies, those, my lord, deficiency and the anomalies. So there, my lord, DPI should see the clause 17. What DPI has done, can you see? He has not invoked the clause 17. He has clause 15. You also can come to adjustment.
And you have placed the student in the Park Hotel?
Yes. And you also really appreciate. Then I say yes.
That's why they have said that is the honorable.
Well, you also can appreciate. These are all question of fact.
That is why, my lord, adjudication to be made by the appropriate forum. If the clients are over-friendly, whether they are over-friendly or less friendly, well, that to be adjudicated by putting someone in the job.
No, these are the reasons they have said that the names of the students may not come to the light. That's why they have said.
No, you see, they have eschewed what I'm trying to submit. This is the point. But you also, I have invested. There are civil consequences. When I say submit your candidates, if at the first stage, the threshold is dismissed, I have nothing to say. The court has given the scope. Now, when court has given the scope, whether court can invoke the subject judicial review or scrutiny or not is a point. My first point, one of the points they have taken some complaint that I've already answered. They are placed in the Parks Hotel. I have no wrong because I am in an obligation to place the students in defined workplace. I place
the student in a workplace where is the environment is not good.
That's why I am responsible for that. Suppose my urology has appointed
the authority to place the students is the.
But urology can appreciate. Urology will appoint me as a.
How college shall base the liability upon whom? You are the person.
But urology then can you see the college should suppose I answer. Urology will appoint me as a special officer to see on property. I'll go there. I will do some misconduct. You also give me a show cause and give me a chance to rectify. That happening in our High Court and the judges also. My lord, here, so Justice Dr. Punamdar said, these are the anomalies. Although these are not the anomalies coming with the clause 17. So I should get a scope. My lord, if the college authority asks me, Mr. Ablon, you should not place those students in future, then it will be terminated. Then no scope because of money. When I ask for the money, the basic thing is when I ask for the money, they have taken this. But you also can appreciate. I am placed in the Park Hotel, my lord. My lord may go, I may also go to the Park Hotel. But these are all workers are there. So
You are the expert. You are the expert to do the BBA like that. The
well, your
college is
lordship,
the
well,
only
no, no,
affiliated person.
BBA, my lord, they can say they are the books, or but these are not the anomalies. What I am trying to submit, my lord. Suppose I have placed a student in a park hotel. There's some misdeeds. This is not my anomalies. What I'm trying, you also can see clause 17. I am in the clause 17. Now, what, my lord, DPI has not looked in the clause 17. DPI has looked in the clause 15. Can you see? Yes. Well, can you see 321 for a moment?
Yes. I'm in 321.
One submitted annual monitoring, can you 321? I started first from here, man. But earlier paragraph, 320, I just start. Therefore, the question remains as to what actually prompted the governing body of the said policy to arrive at such painful decision, discontinue BBA, to unearth the real cause. Then skip over, come, my lord. In clause 15, at page 321, in clause 15 of the said MU, it laid down the governing of the said college shall review the progress of the decision and renew the agreement on the basis of the satisfactory performance to annual appraisal report submitted by the second party. But this is, my lord, this finding is bad. It is subject, my lord, here the honorable single judge was pleased to direct them to look into the grievances. My grievances is that, my lord, it has been terminated by invoking clause 17. And DPI, instead of clause 17, he relied on clause 15. At page 321, my lord.
Yes.
This point has not been, my lord, they have not advanced their argument on this point. Why clause 15 can be invoked in the present case?
Very well. Yes, Mr. Rai, anything further?
Secondly, my lord, just a minute. My lord, regarding monetary reliefs, my lord, regarding last, so my lord, in my notes of argument earlier, I said the submission. These are the points I said, can see those points have not been dealt with by them.
Very well.
My lastly, my lord, monetary claim.
Monetary claim is always open.
No, what I'm saying, my lord, in the earlier revision, monetary relief is not the prayer. You also can appreciate. And in the written submission, I'm not saying, but it is not incomplete, so I can't say more strongly. I'll see. But DPI has said, my lord, and see the order.
31,66,201.
And what he said. With the approach observation, the matter assigned to undersigned by the Honorable High Court, we have disposed of backward partial nature of undersigned is dum-dum, admitted dues. How DPI has got it? DPI has not asked for any documents from us. 85% is my money. How he got the admitted dues? My learned friend submitted in the last occasion that is a monetary
You
claim.
have accepted the due. You have accepted the amount.
My lord, yes.
Why are you raising this question?
No,
Before this
my lord,
court?
you also going to appreciate. They have sent it. They have sent to me. This is money. So you also can appreciate. They have sent to my bank. You also can see.
Putting endorsement on the my lord on the
No,
check.
Sorry, I said, I take it. No, man. I took the check. But man, what's my point? Besides, I've taken this money. The debate is at my admitted amounts. On what basis? What is the breakup? Debate has arrived at these findings on the basis of the report of the college authority. Then he should ask. My learned friend said, if there is some other outstanding dues, you go to the civil court. I place on judgment, that is ABL, my lord. Monetary claim cannot be asked for in the writ petition.
You also not prayed any relief in this writ petition regarding monetary relief for that? You have not. No. You have not prayed for any relief. How can I entertain your prayer? You have not prayed for any relief.
I answered to my learned friends. My learned friend says that there may be a dues.
Very well. Say he may argue like that.
But then I'll place on
It is
judgment.
always open to you to claim the relief, claim the money.
No, your lordship, can you
the
see?
due.
Yes. Civil court যাব কেন? But now I'll show one judgment, my lord. The judgment of my lord, your lordship can see ABL or High Court or Honorable Supreme Court says many judgments 1969. Monetary claim cannot be asked for in the writ court.
Yes.
If it is a consequential relief, that can be asked for. Here, my lord, is a consequential relief.
No, you have not prayed for any.
Consequential relief can be, my lord, my lord, can be taken into by the court, my lord.
Must not.
Must not. No, my lord. Subject,
no, Mr. Roy.
Subject to lawsuit correction. I can't develop, but I point out one thing, my lord. The writ court can mold the relief. So the relief can be molded on the basis of the order of the DPI. DPI says admitted due.
This court tried to mold your relief regarding monetary claim. That would be go against you.
My lord, your lordship can appreciate. My learned friend says the outstanding dues, they can go. So they also admit that I have outstanding dues. Yes, my lord. My lord.
Very well.
This supplementary motion I just make it.
Okay, you sir.
This.
Only one sentence. By filing their affidavit in reply in the earlier round, they have denied any kind of harassments, be it sexual, be it mental, and all this paragraph 11, page 17. Denied it. And at the same time, my lord, before DPI, they have emphasized in written notes of submission the above the entire focus has been laid on the allegation of termination of move was nothing but a counterblast to their claim of 85%.
Yes, I have read it. I have read it. I want to see the written notes of argument of the petitioner, but I have not seen the written notes of.
I have given. I have given.
No, this is not complete. This is not complete written notes of argument.
No, written notes of the no, my ওটা পুরো নেই তো আমাদের তো না my notes are there. My lord has pointed out. My lord.
Yes, I have not seen the
transfer brief.
I understand. Page 65 what? Read petition.
এখন দেখেছিস না
Account summary.
Document, my lord. He has upon this evidence, my lord, this
Very
of 2022 itself.
কি বলছে
Okay, thank you.
Yes.
Argument on behalf of the parties concluded. Made safe.
The patient hearing given the my lord, we are
No, I allowed Mr. Rai. That is the the day before yesterday. I have heard you. Mr. Rai was heard long before. That's why I'm allowed him to argue on the point.
My notes of argument is there.
given to all of us.
To recapitulate, my lord.
Yes, to recapitulate.
I know that I have that liberty to argue before lawsuit, so I know. Madam, I may. Madam, for last, these are my friends, my brothers. Here, we are argue only this. But your lordship knows this. It is over here now. On the outside, we are.
Very well.
Yes, ma'am.
Thank you. Next matter.
Number 6.
I am for the petitioner. Private respondent. Your lordship may remember, or last occasion, your lordship passed an order that if they don't appear, then the matter will be taken up expedited. This is a case where my lord, camera hearing has been concluded. In respect of a particular vacancy, writ petitioner has applied in separate vacancy. Now challenging my selection, which is in a separate place, separate location, separate notification. Shall we see the order dated 4th December? These are dismissal because they are not willing to move the case because there is no case has been made up. And while allegation has been raised against one woman that she is married, but fact remains she is not married. That is the case made out in the writ petition. In respect of a particular vacancy where I have been selected and license has been granted, but he applied in a vacancy which is not the subject vacancy. That's the case of the respondent. And there are, before that, an order has been passed to submit supplemented affidavit annexing the document showing that he has applied for in respect of my vacancy. No report has been, no affidavit has been filed. This is 6th of November 2024. If he comes, my lord, in that case, I shall pay for a huge cost. Possibly he will not come. Can you see the order dated 6th November? No report, no affidavit. Second paragraph. The wild allegation. On my request, you will also heard this matter on camera. As the last chance. Have you not seen the last order?
Petitioner has challenged your selection.
But he did not apply at that place. He applied in the separate place.
No,
All documents says he has applied in respect of a particular vacancy, but now challenging my vacancy, saying that he is also a candidate in respect of my vacancy.
So he challenged the vacancy notification and your selection in respect to notification number 125.
Yes.
SCFS Rampurhat.
My lord. And kindly take up the report submitted by the state.
Report.
Page 13.
Yes.
The memo number.
125 SCFS Rampurhat.
My lord. And so far he is concerned in his writ petition, if you not kindly see. I have applied against my page number 30. And so far he is concerned. Separate location, separate place, everything. It will appear from page 17 and 18. Page 17 serial number, your lordship has marked last occasion. 15, 16, 17, 19, my lord. Page 17. And he has applied in next page, separate location, right hand side, 16, Durga Mandir, and at page 19 of the report, this is Vishal Gupta applied. Kindly see payment in respect of the application fee against 10 application of reference. Right hand side, last column, payment reference number. This is Vishal Gupta, petitioner.
Page
19
of the report.
His online application fee. Right hand side, last column, top, payment reference number 10 SCFS. Have you also got my lord? Vishal Gupta, depositor's name, 10 SCFS. And so far I am concerned, my lord, 125 SCFS, that is page 30.
This is reference 10 SCFS.
My lord. Also in page 21. They have also annexed there in the repetition page, my lord, 34, near Durga Mandir.
Where is the 10 SCFS notification?
Just I'm keeping. That is Durga Mandir. Page, my lord, 9 of the report.
Page 9.
My lord, of the report.
10 SCFS Birbhum.
Location and vacancy ID number, second line, first column, ID 202 last 102. And their repetition page 34 tally with the same.
10 SCFS.
Yes, my lord, this is Horidaspur near Durga Mandir. And my application at page 13
Your application is page 13
of the report. 125 SCFS that has been annexed by the state.
125
Ward
SCFS.
number 05, ward number 05. Have you also got, my lord?
Yes.
Separate location, number is separate. Page tally with the page number 9. And the entire advertisement, page 17. First page, serial number 18, 10 SCFS. Have you also got, my lord? Page 17, serial number
10 SCFS.
My lord. And next page, right hand side, serial number 16, 125 SCFS. Have you also got, my lord? Right hand side table, column 16, 125.
Yes.
Then his application fee, page 19, 10 FPFS.
10 SCFS.
My lord. This is separate location, Durga Mandir.
10 FPS.
Vishal Gupta. All documents. Then page 21, he has been called for inquiry has been conducted, 10 SCFS. ID number. Durga Mandir. He never raised any objection.
Okay.
So these are dismissal with cost, my lord. Serious allegation, wild allegation. And so far my concern, page 28, kindly see. 125, kindly see. My application. Page 28. First column, second column, right hand side, 125 SCFS. Have you also got?
Page 28.
My lord, of the report. R9, name and designation of inquiry officer, date of inquiry. Then on right hand side, findings, ward number 05, Nalhati municipality, 125 SCFS. Have you also got, my lord?
Yes.
Right. Mukesh Lokneshwar is my client. Serial number 9 possibly.
This is the inquiry report.
Yes. And while allegation against my sister that she has married a super dealer, I never find any term of super dealer. Accordingly, I am not entitled to.
Okay, please take down. হয়ে গেছে যেটা দিয়েছিলাম বড়টা আমি ঠিক আছে
Some caution may be given at least, my lord. Such type of wild allegation against a lady who is not married with some photographs that she is married. Some manufactured documents, no Aadhaar card, no ration card, nothing, only some photos.
This kind of litigation is also an embarrassment to the state officials also.
Absolutely. Some caution or costs must be, my lord, awarded.
What are the allegations?
Allegation, kindly
Paragraph?
My lord,
Read petition
the
paragraph.
writ petition. Yeah. Just I'm giving you. Page, my lord. 7.
Page 7.
Paragraph 6, bottom portion. Most of the family members of the private respondent are government employees and working in the prestigious post, having sufficient salaries and so on. So, elder son-in-law, kindly see, elder son-in-law, namely Niranjan Datta. There is no MR distributor in Birbhum district in the name of Niranjan Datta. Is ration super dealer. I have never seen, my lord, this term, ration super dealer. Within the area of Nolhati under West Bengal Public Council, proposed selected private respondent suppressing the material facts, that is the elder son-in-law, Niranjan Datta. Then after some lines, left-hand side sentence that it appears from the voter list that Mukesh Lankeshwar is the son of Sunil Lankeshwar and the wife of Niranjan Datta is Nokso Ansu. It is fact that Monisha Lankeshwar, wife of Niranjan Datta, are sons and daughters of Sunil Datta. Where from he is getting this, if you want to kindly go through.
Okay. Please take
This
down.
wild delegation.
Yes.
State also filed report.
Take it.
In the form of a video.
And we have filed our exception also. Not exception, opposition to the petition, because we are supporting, the state is supporting us. And the affidavit in reply, just if you also kindly take up page 21, how these manufactured photographs have been prepared and annexed. This is a lady, page 16. So all manufactured, my lord.
On behalf of the state, the submission of the state is two sides are totally different.
বলেছেন। The lady is yet to marry. This allegation has been brought. Some cost is required to be imposed in this case. I never prayed for that in any matter, but these persons should be alert how they have coming before the court. They should be cautioned.
Please take down. Instant writ petition was filed by the petitioner challenging the selection of the private respondent for issuance of fair price shop dealership in respect of vacancy wide notification number 125 SCFS stroke Rampurhat dated 3rd March 2022. It is the brief fact of the petitioner that he applied for the license in respect of the said vacancy notification. But the private respondent, in collusion with the respondent, state respondent, procured the license. It is the allegation of the petitioner that most of the family members of the private respondents are government employees and working in a prestigious post, having sufficient salary, and the elder son-in-law of the present petitioner is a ration super dealer.
A private respondent.
Elder son-in-law of the private respondent. Private respondent is a ration super dealer within the area of Nolhati. He also alleged that one of the daughter of the private respondent had married with one ration dealer. Full stop. The private respondent appeared in this matter and filed their affidavit in opposition against the writ petition. Full stop. The state authority also filed a report in the form of affidavit. During course of hearing, it has been vehemently opposed by the private respondent that the petitioner had imputed the allegation in the writ petition against his daughter, who is still unmarried. He further submits that
Sister.
sister. ওই যে কি বললাম? His sister, who is still unmarried, but the writ petitioner has stated in the writ petition through affidavit that unmarried lady has given marriage. Full stop. On considering the gravity of the allegations, this court has conducted the hearing on camera. Full stop. Matter was heard in part. Full stop. Today is fixed for further hearing. Next para. On call, none appears on behalf of the petitioner. Semicolon. No accommodation is sought for. Private respondent as well as the state respondent are present. Full stop. Having heard the learned counsel for the parties, also considering the materials in the writ petition, it appears that writ petitioner challenged the selection of the private respondent in respect of vacancy notification number 125/SCFS/Rampurhat/2022 dated 3/3/2022. The state authority has submitted a report and has annexed the notification at page 13 within bracket annexure R2. the impugned vacancy notification detail about the location of the vacancy as 1 number 5, 1 number 5, Nolhati Police Station, Post Office Nolhati, PS Nolhati, District Birbhum. কি বললাম বলো? ঠিক আছে। হচ্ছে Annexure P3 of the writ petition is a document which is the receipt of which is the information of concerned authority to the petitioner in respect of the inspector inquiry at the proposed shop-cum godown of the petitioner with vacancy ID number with vacancy in respect of the FPS vacancy at near Durga Mandir, Horidaspur, within bracket vacancy ID number 2022 00 225 102. Full stop. The notification at the location of vacancy in Horidaspur near Durga Mandir was notified by the concerned SCFS on 6th of January 2022, having vacancy ID number 2022 00 ageta 225 102. Full stop. The said notification was placed in a report of the state authority as R1. Yes.
Lordship is disposing the matter.
You are not there, that's why
I am just stuck on court number 8.
One was there. How can I have with this matter for long 15
Lordship, I'm
years.
sorry, Lordship. Lordship, I stuck in court number 18. I requested my learned junior, but nobody.
One is there. That's why I started the passing judgment. However, if you want to say anything.
Yes, Lordship, there is a direction for filing a report. Your Lordship directed me to file a report whether there was any application in respect of this plot in question.
Yes. You have not submitted any supplementary affidavit or report.
Lordship, to that effect, Lordship, I want to say that, so filing the report is concerned, Lordship, the petitioner has filed the offline application.
You have also argued on that point. You have already argued that you have filed on offline application.
Offline application. Now, Lordship, what happened? Kindly come page 31 of my writ petition. I filed an offline application, ward number 5, Nolhati.
Where is the receipt of your application? You see page 34. In terms of your application, they have informed that one.
Yes, Lordship, this is the fact that this offline application I submitted before the authorities. Now, in the online application, that is the receipts of online application.
Not receipt, this is the report. This is the intimation that there would be some inquiry in terms of your application.
Lordship, yes, but when I filed the online application, Lordship, kindly come to my payment receipt, I have annexed in the opposition.
Yes, you see the payment receipt. I have seen the payment receipt. At the report, the state authority has submitted the payment receipt, your payment receipt.
Yes.
Where is the page?
Payment receipt.
In the state report, there
Yes, page 20.
Page 19 is the payment receipt.
Yes, page 19. Yes, page 19 is the payment receipt.
Your reference 10 SCFS.
Yes, 10 FESS RH80 22.
Yes. That is the notification at page 9 of the report. Ten SCFS.
Yes, Horidaspur near Durga Mandir.
Yes.
In this matter, I, through offline mode, Lordship, submitted my application at page 31. That is ward number 5, Nolhati. When it is an offline, the receipt has been issued, that is the different place.
I don't know how can you
According to the respondent, that is
receipt. You show me a receipt, offline receipt, anything. You show me a receipt that it is of in respect of 10 SCFS, not 125 SCFS.
yes, that is the fact is, Lordship, the page 31 is my application submitted before the authorities. Because there was both the mode, the petitioner can file their application, that is offline and online. Offline, the petitioner this is the petitioner filed the offline application, ward number 5, Nolhati.
Mine is not permissible, only online. He has participated in the inquiry proceeding in respect of a separate location.
Yes.
Now I shall.
Lordship, kindly.
If you short to substantiate
yes.
case, my lord, I shall pay for a huge cost, my lord. I shall pay for a huge
I
cost.
am the petitioner, I have not able to submit my case.
Yes.
Lordship, kindly come page 10 of the report. The application can be submitted in the following mode.
No, I understand. Whatever been the mode. You have applied for different license and now you are challenging different license.
No, so kindly come. He said that only online mode is applicable. Kindly come page 10 of the report.
Forget about the online application or offline.
There is a three way.
A single instance, single receipt that you have applied for 125.
Yes, so kindly come see 5C, clause 5C. By hand in a sealed cover. There is a process of filing application. That is, application can be submitted in the following mode. Online mode. Kindly come page 10.
No. How can you argue like that? You have given given the money. They have received the money received. Give you the receipt. You have seen your receipt. Now you are saying that I am for another location.
Inspection was conducted.
No, you see.
Kindly come clause 5. Let's kindly come clause 5. Clause 5.
No, I understand. I understand the online, offline, both applications are.
Yes. So this is my offline application. This application is valid as per the notification.
When you have, why valid? You show me one instance that you have filed.
Lordship, kindly come 5 clause C.
No,
by hand in a sealed cover. There is no need of
seal cover. I say, where is the seal cover? Copy of receipt.
I have submitted before the authorities.
Okay.
That is the application.
You have deposited the money and you got the receipt. You got the receipt.
Also, kindly come page 10. Kindly come page 10.
I have read out everything. I am asking. I am here to accommodate you.
Yes.
Whether you have gone to the wrong notion or not. That has to be proved by you.
Lordship, my submission is...
Your submission is you have applied for 125, but the authority has turned your application as 10, SCFS 10.
Different plot, different area.
They have issued you a receipt. They have issued you a letter for inspection. You participated the inspection. Everything, everywhere it has been written 10 SCFS, Durga Mandir. Near Durga Mandir. You have gone to their proposal. You have accepted their proposal. You have received the receipt, money receipt. Everywhere they have stated that.
So they have issued the money receipt. Lordship, this is the crux, Lordship. This is the conspiracy has been done.
Oh, conspiracy has been
This
done.
is the
then
conspiracy
you
has
have
been
to
done.
approach before this court, before selection. When you see your money receipt is in respect of different location, you must have approached this court. You must have raised any question. This is not my location.
No, my specific, Lordship, the averments in the writ petition that I have applied offline mode, ward number 5, Nolhati 125 SCFS.
No. Your pleadings is not sufficient. Your documents are there.
Kindly come page.
Your
that
sole
is the,
documents.
that is the, Lordship, my case is.
Page
Lordship,
34.
Lordship, kindly come page 21 of my report. There is his signature. Inspection report, inquiry notice. He signed in the inquiry.
That I am asking.
So why
Why sir?
get that?
You accepted, you kept silent.
Page 21.
Yes, I have read. Page 21, page 19, all are the documents they issued.
Page 32A of
Lordship,
the
kindly record my submission that page 31 is my application. I submitted ward number 5. That is not this. Lordship, I am not contradicting with the Lordship others. That is 125 I have applied for.
Okay. Yes, I have noted.
And Lordship, there is a mode that I can hand over the Lordship the offline application through a sealed cover. I have done. That is the notification.
But no money receipt.
দাদা বলতে দিন, আপনি তো বলেছেন তো, এতক্ষণ তো বলেছেন।
No, when you filed the application? When you filed the application?
Lordship, the 17th June 22.
No. 17th June 22. Where is the date?
No signature, no date.
No, signature is there.
Where is the signature? To manufacture documents.
Yes, name of the applicant. This is
It's saying yes. Manufacture document is replies yes.
Where you?
Kindly come page 32. This is my signature. Problem is this.
Where is the date? When you filed? Why is the date is vacant? Nothing is there.
Only document is the acknowledgement. Is required.
No, there is no requirement of acknowledgement. This is the Lordship, the law. This is the as per the notification seal cover. So I have submitted the seal cover.
Okay, hard.
Now, Lordship, the second limb of the Lordship, the writ petition that against the private respondent. Lordship, I have submitted
No,
a
you have no locus standing. You have applied for.
Lordship, kindly record my submission against that what allegation I have made.
Allegation you have not substantiated. I have given you opportunity to made hearing. This type of allegation cannot be entertained by this writ court. First of all,
This is the Lordship, the regulation does not permit the private respondent because the private respondent is not eligible. Lordship, kindly come my affidavit in reply. I have filed. This is affirmed on July 2024. Lordship, kindly come to my affidavit in reply. Lordship, kindly consider this. First of all, kindly consider my paragraph 10, Roman 10.
I have also gone through the entire affidavit. I have gone through your entire affidavit. He has married with another person like that.
Yes.
But you have not substantiated any of your allegations.
Yes, I have substantiated. Kindly come.
Picture, photos.
No. See, Lordship, the affidavit in opposition by the private respondent.
In such a way, imputation one person, one lady cannot be put into the court.
Lordship, this is admitted fact that she is married.
First of all, you have to prove your locus in a writ petition. Thereafter, I can enter into.
Lordship, this is my opposition. This is my reply to the opposition. Opposition what filed by the private respondent. Lordship, consider this and pass on.
Okay. 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 Very now, কি বললাম বলো?
আগে যখন দেখছো মামলা ধরছে তোমাদের লিস্টে দেখছো না মামলা ধরেছে
as কি বলো?
কি
তারপর কি লিখেছো? Having heard the learned counsel for the parties, yes.
দেখো 14 দেখো না
Yes. Is a document.
14
Annexure. Follow. For vacancy ID number 202200225102. Notification was placed. Notification was placed by the state at their affidavit as annexure R1. The annexure R1 is vacancy notification number 10 SCFS 10 stroke SCFS stroke RH80 stroke 2022 dated 6th of January 2022 in respect of the location of Horidaspur near Durga Mandir. Full stop. Annexure P3 page 34. Bracket page 34 of the writ petition is a intimation of the authority concerned to the petitioner, informing him about the date of inquiry in respect of vacancy at near Durga Ponni, near Durga Mandir, Horidaspur, within bracket vacancy ID number 202200225102. The state authority has also placed on record the receipt of payment regarding the application fee of the petitioner dated 18th of May 2022. The receipt is also depicted the vacancy notification number 10 SCFS 10 stroke SCFS RH80 2022. Document shows full stop next one. Document shows that the petitioner has applied for the vacancy bearing notification number 10 SCFS stroke RH80 stroke 2022 while the petitioner challenged the selection of the private respondent in respect of vacancy notification number 125 stroke SCFS stroke Rampura dated 3/3/2022. Full stop. Learned counsel for the petitioner submits that the petitioner has applied for the said vacancy through offline mode by placing a sealed cover at the office of the concerned SCFS. He placed a copy of the said application with this writ petition at page 31 within bracket P2. It appears from the copy that this application is undated and no document is placed with the said application copy of application when it was received. Rather, the receipt of application and fees for the said application is in respect of 10 SCFS. The state also submitted a report containing inter alia that the petitioner has applied for different vacancy notification and the private respondent was selected for the vacancy notification dated 125 SCFS Rampurhat 2022. Considering the same aspect, it appears to me that the petitioner who have never applied for the vacancy notification dated 125 stroke SCFS stroke Rampurhat 2022 dated 3/3/2022 has no locus standi to maintain a writ petition. Full stop. However, the allegation raised by the petitioner against the private respondent and the affidavit in reply against the allegations and the affidavit in opposition against the allegations, more so affidavit in reply against the said opposition filed by the petitioner is not taken into consideration by this court. Under the above observation, the instant writ petition is disposed of. I find no merit to entertain the writ petition.
But dismissed or disposed of, my lord?
Dismissed and disposed of.
Lordship, kindly record my only one submission that in terms of the regulation, the private respondent is not eligible.
It's a locus.
Yes.
It cannot be recorded, my lord. It's a locus.
Okay.
I'm good.
Next.
Assigned matter, item number 8.
My lord, I am led by Mr. Apollo Basu. I'm for the respondent, my lord.
My lord, I am for the petitioner, my lord.
Item number
8.
8. Yes.
My lord, on the last occasion, I was directed to serve upon the petitioner the affidavit in opposition. So I have already served it, my lord. Is the copy?
My lord, on the earlier occasion, my lord, it is directed to the to reply to the respondent affidavit opposition, my lord. Here is reply, my lord. And my lord, also the I surveyed a copy to the respondent, my lord, in the court, my lord.
So, who is appearing for the husband?
My lord,
Opposite party number 1, you.
Yes, my lord.
You filed the affidavit in opposition.
Yes, my lord.
So, you are filing the reply.
I filed today, my lord.
You are filing today.
My lord.
Very well. So, it is an application under section 125 CRPC.
My lord.
So who is the petitioner here? You are the petitioner. Wife
My
is the
lord,
petitioner.
wife,
Why you
wife.
came to this court?
My lord,
Why you came to this court? What order you have challenged?
my lord, earlier the order is challenged before the another court by my lord. The husband went to the Supreme Court and
No, forget it. The circumstances is over. Now
yeah, my lord.
we are in a position to hear out the instant revision.
My lord, then fix it, my lord.
Okay, your interim maintenance application
My lord,
under section 125 was rejected
my
on
lord,
contest.
my lord,
That was challenged in before this court.
my lord.
আচ্ছা আচ্ছা হ্যাঁ হ্যাঁ সুবিধা মতো করলাম তো আছে ঠিক আছে যাই অসুবিধা ফিক্স করছি সেটা ফিক্স করছি হ্যাঁ হ্যাঁ আচ্ছা আচ্ছা ঠিক আছে Yes.
My lord, I was opposing his application. On the
Yes,
proposal.
let the petitioner be heard first. What is your ground?
My lord, then fix it, my lord, for the hearing, my lord.
Today is the date. We have time now. Start the hearing. Have you gone through the records?
My lord, my lord. My
Have you
lord,
gone through
Mr.
the
Gupta
records?
is appearing
It
for
is the
some.
opinion of the magistrate. This is the proceeding of interim maintenance. Opinion of the magistrate after taking the all affidavits, asset declaration by both the parties, that the income of the parties are not so dissimilar. There may be dissimilarity, but not so dissimilar. That's why interim maintenance was refused. You have your specific earnings. You have placed the document before the magistrate. So where is the perversity?
My lord, Mr. Gupta is appearing for the petitioner, my lord.
Appearing?
Mr. Gupta, Mr. Pawan Gupta. My lord, kindly fix it, my lord. Kindly request, my lord.
Then I cannot.
Kindly have it in the month of February. Then in that case, my lord, I'll tell you. Cut short, long story short, my lord. As my lord has seen the records, the income of the husband, as per the whatever documents, affidavit, assets and liabilities, was about 38. The wife's income, admitted position, I'm just indicating to your lordship, was about 28,000 something odd, as per her disclosure. The learned magistrate, the interim stage, was of the opinion that since this is only for the purpose of interim adjudication, not on the evidences and merits of the case, so whether even if we come to the framework of 1/4 or 1/3, it is anyway more than this 1/3 or 1/4. Even today, if maybe 11,000 or 10,000 is awarded, which can be 1/3 of my income, then it will take her income to be 40,000 odd, and my income will come down to again 28,000. To keep that balance intact, it was rejected. They moved this honorable court against that order. The order was supposedly, the order was set aside on this court and it was remanded back. We moved the Honorable Supreme Court. The Honorable Supreme Court had again requested your lordships to reconsider the matter. Now, my lord, the affidavit in opposition was filed earlier. They have filed today the reply. Perhaps, my lord, he's been led by Mr. Gupta. My lord, fixes any date in the month of February in that case. My lord,
February, tomorrow, what is the date?
tomorrow, my lord, tomorrow, Govinda.
Very well. If you are wanting on February, I will give you February. When?
no.
When? Give me February when? Give me a specific
February
date.
bol ekta
I shall dispose of the matter.
In the
Direction of Supreme Court is there. You know the issue.
second,
I have to dispose of the matter.
well, in the second week of any date, my lord.
Second week starts from 10th.
I would kindly not keep it on the 11th because my lord Justice Honda Manager has just kept one of my matters at 2 p.m. on 11th, except for 11th, any date.
11th of February.
11th of February. That much on 11th. Apart from that, any date which suits my lord's convenience. Opposition to file for you.
Affidavit in opposition file on behalf of the husband opposite party number 2. Husband opposite party number 2 is
My
taken
lord,
on
would be
record.
one, my lord, my lord.
One
Opposition
one or two?
One, my lord. I don't know. One, my lord.
One.
My lord, they have made the state the formal second party, my lord, in the
Okay.
application filed by them.
Opposite party number husband opposite party number 1 is taken on record. Reply by the petitioner is also taken on record. Matter is otherwise ready for hearing. Let the matter fixed on February 12th.
February 12th. I am deeply obliged.
Under the heading of hearing. No.
Assigned matter, my lord.
Under the heading of assigned matters.
Same here.
Next.
Great.
Thank you.
71, my lord, I am appearing for the petitioner. My lord, in earlier occasion, your lordship directed to file opposition to my learned friend. Though in earlier occasion, 3 occasions, there was a direction for filing opposition. My lord, yesterday,
What is the matter about?
my lord, matter about that is the I am challenging in the writ petition the notice sent by the my lord Farakka Barrage authority my lord, to attach the pension in my quarter my lord, that is rent as a rent in the pension account, and that was challenged in the writ petition page 55 7 January 2021. The notice has been issued by the Secretary of the Government of India, and after that direction has been given to file opposition, and I file an CAN application for staying the operation of that notice, because in earlier occasion another writ petitioner got injunction order from this Honorable High Court. For that reason, my lord, I am prayed before your lordship to similar order may be passed regarding the writ petitioner, and in earlier occasion your lordship directed to file opposition in respect of writ petition as well as in respect of CAN application. Yesterday they served the copy of the opposition.
Do you want to use
Yes, my lord, I am filing, my lord, my reply, my lord, after 10 days, any date as your lordship convenience, kindly fix the matter. Within 10 days, I will file my reply. And regarding my lord, writ petition, they did not file any opposition. Regarding CAN application, only they file opposition.
Whatever maybe, we shall dispose of the writ petitions. Very well. Please take down. Affidavit in opposition on behalf of the respondent number 1, 4, 5, 6, and 8. In respect of CAN 1 of 2024 is taken on record. Petitioner intends to use reply against the opposition. Let the reply be filed within 2 weeks from date. Let the matter appear in the list under the same heading.
17th,
17th of February.
17th February,
17th of February.
under the same heading.
Under the same.
Grateful. Grateful matter.
Call next matter. Motion. দেখুন মোশনে কি আছে দেখুন
20.
6.
Let I pay for the petitioner.
My lord, General corporation is a big part, my lord, this part of our heat absent, my lord, without.
Have you served?
On last occasion, Lordship has passed an order on
Which
third.
appearing? Mr. Chakraborty was appearing?
No, my lord, no. কি নাম বলুন?
Respondent number Shubhendu Haldar, Obirup Haldar.
This of the matter, my lord, tomorrow morning, my lord.
Morning হবে না।
বলে দাও। Main answering respondent.
Lord, what your Lordship can remember, this is a matter where my Lord, a petrol pump was the dealership of the petrol pump was granted by the IOCL in favor of a partnership firm. I am the owner of the property. I am the owner of the land. The entire infrastructure is on my land. To run the business, my lord, I enter into a partnership with the private respondent. Now, my lord, before the letter of intent could be issued, he retired from the partnership. But after the letter of intent was issued by the IOCL in favor of the partnership firm, my lord, both the partners signed the agreement. Now, thereafter, my lord, the business was run by me alone.
No.
There was, please, my lord, there was some dispute between the partners. So I was running the business alone. Now, that is the crux of the matter, because
And they have terminated the license.
terminated on the ground that I have not disclosed that the partner
Change of partnership.
change of partner from partnership to proprietorship. On that ground, the license was cancelled. Now, my lord, thereafter, I made a fresh application that I am the owner of the property, the infrastructure to run the petrol pump is there, and I want the license in my name individually. And there is another embargo from the state government, my lord. I have shown the notification also that once the land is used for a petrol pump, the nature and character of the land cannot be changed.
Yeah.
So
You are suffering.
I am suffering because of my mistake. I face the consequences of termination of the dealership. Now, my lord, I want it to run it individually in my name because I am the owner of the property and I wanted to run the business.
Now, what is your prayer before this court?
I made a representation before the authorities to consider my representation, stating all the facts that these are the background for which the license dealership was cancelled. Now I am making a fresh application, and since the land I cannot use for any other purpose, so kindly consider my prayer for grant of individual.
Where is the equipment, sir, over there?
Everything. My lord, the entire infrastructure is still there. The pump, the reservoir, everything.
They have
For
not lifted the.
nothing. So that was my prayer. And my lord, I cannot use the land for any other purpose also.
Where is your representation?
My lord, the representation is at page
I am going to respond. 160.
169 also, 163. There were two representations, one main representation at 163 and a second representation at 169. Same content, my lord, I have also annexed the documentary documents before the authorities that I cannot use the land for any other purpose also. So kindly consider it in a pragmatic and sympathetic manner. And my lord, the notification, kindly come to the notification at page 162.
Yes. Government of West Bengal.
Yes. I cannot use the land for any other purpose. No, he is a private respondent, my lord.
I am objecting this.
Why?
My lord, I am the, my lord, one.
You are the partner who left.
Partner, my lord. No, no, my lord, I left, my lord, before that, my lord. He, self some cause of action, my lord, he filed a writ petition.
That has nothing to do with the issue.
Challenging the termination.
Lord, I had initially filed a writ petition challenging the termination. Thereafter, I withdrew because I knew that I cannot challenge it straightway in the High Court. There was a arbitration clause also between. So I accepted the termination. So now nothing remains in the earlier part, my lord. Now this is a fresh application for consideration.
Self some cause of action, my lord. He filed a earlier writ petition, my lord. I, my lord, surrendered my partnership deed, my lord. My lord, on my lord, in the year 2011, my lord, a proposed deed was not submitted before this IOC, my lord. In the year January 2013, my lord, IOC.
What is your objection regarding their representation before the authority?
My lord, my lord,
Authority be considered whether they are applicable or not, or I can also assure the authority. Authority can refer the matter to the arbitrator or anywhere.
Now the question of arbitrator also does not arise because the agreement on the basis of which I was granted the license, that has been terminated. And I have not challenged the termination.
What happened in the earlier writ petition?
Lord, I withdrew it, that I did not proceed. I did not proceed.
That, my lord,
That I have annexed the order also, my lord.
my lord, they preferred the writ petition, my lord, to surrender my lord partnership deed, my lord, in that prayer also in the earlier.
Whatever may be the earlier fact, let the petitioner be prefer the application before the authority.
My lord, last occasion your lordship heard this matter. The IOC, my lord, the landed council appearing on behalf of the IOC, my lord, responded 256 accommodation to demonstrate the matter before this court within some instruction. My lord, he has taken instruction, my lord.
I don't know what instruction he has
My
taken.
lord, in the
In a matter of
the date fixed, so why he is not appearing? How can I do?
my lord, he is appearing
Millard.
in the morning.
Oh, now I am out of time. Otherwise, they can.
Millard.
Tomorrow morning, first matter. First matter.
First matter.
Is it difficulty?
No, my lord.
No.
Lordship.
Okay.
Morning.
Morning, first matter. কি আছে কালকে মোশন নেবেন না মোশন দেবেন তো মোশনে কি আছে মোশনে কি আছে
বলে দিচ্ছি 2 PM করে দিচ্ছি 2 PM. My lord,
ধরতে হবে তারপর
my lord, kindly keep it at 2 PM because I'll give notice as a petitioner. My lord, I'll give notice to the IOCL and the advocate.
Is the requirement, but this is running in the list.
I understand, my lord. Otherwise, my lord, they will come and say that my absence.
Okay, okay. You serve notice.
I'll serve.
2 PM. I have some fixed matter. That is the difficulty.
Kindly one
Okay,
o'clock.
I am fixing at 2 PM. I am fixing at 2 PM. You serve notice. Okay.
Oh, my lord.
Petitioner is directed. No, none appears on behalf of the IOCL respondent. Full stop. Petitioner is directed to serve notice upon the respondent within bracket IOCL. Let the matter appear in the list tomorrow. On tomorrow, that is on
15th. Tomorrow is 15th, my lord.
কি আছে কালকে
নালে ইয়ে 1 PM সাবজেক্ট কনভিনিয়েন্স
একটা ছোট মাটা শুনে নেব আছে না
My lord, subject to my lord's convenience, can it be taken up at 1 PM? So that 2 PM schedule cannot be changed.
Yes, 2 PM. I have the
Lordship, I have seen lordship has fixed many matters at 2 PM. Make it 1 PM. I'll give notice that at 1 PM.
Yes, 1 PM.
1 PM. I'm grateful, my lord. ঠিক আছে একটা 5 মিনিটের মতো দাদা কালকে